All right, the Senate will come back to order. Senate will come back to order. I recognize the senator from the 8th for a motion.
Thank you, Mr. President. Pursuant to Senate Rule 7-1.10b, I give notice that on the next legislative day I intend to move that the Senate consider House action on SB 59. And Mr. President, I have the wonderful Miss Carly from Willacoochee, Georgia here, and she asked for the same.
Glad to have you with us, Carly. The senator has, Secretary, read the motion. Read the bill.
Senate Bill 59 by Senator Watson of the 11th and others, a bill to be entitled an act to amend Code Section 48-5-7.4 of the Official Code of Georgia annotated relating to referential assessment for bona fide conservation use property and bona fide residential transition property so as to remove a limitation on leased property so as to certain entities to provide for related matters to appeal, provide for effective date to, and applicability to appeal for conflicting laws and for other purposes. Mr. President, that completes the order.
All right, the senator from the 8th has given notice that we will take action on Senate Bill 59 on Monday. Thank you, Senator. I recognize the senator from the 11th for a motion.
Thank you, Mr. President. I move that Senate Bill 551 be removed from the table.
Is there objection? Hearing none, Senate Bill 551 is removed from the table. Secretary will read the caption.
Senate Bill 551 by Watson of the 11th and others, a bill to be entitled an act to amend Chapter 2 of Title 26 of the Official Code of Georgia annotated relating to standard, labeling, and adulteration of food so as to repeal provisions relative to eggs, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Agriculture and Consumer Affairs recommend that this bill do pass. Respectfully submitted, Senator Goodman, Chairman. Mr. President, that completes the order.
I recognize the senator from the 11th to speak to Senate Bill 551.
Thank you, Mr. President. Members of the Senate, this bill is about red tape rollback and freedom. And we have an age-old egg candling law in our state that we need to repeal and take off the books. The candling of eggs is a grading issue. It's not a food safety issue. So we're allowing folks back home in our communities to be able to sell eggs to the public without having to go through the state process of candling eggs. That's what the bill does, Mr. President. I'd be glad to take any questions if there are any. If not, I'll yield the wheel.
You do have a question, Senator.
I'll take one.
I recognize the senator from the 41st.
Thank you, Mr. President. Senator, does Senator yield?
I do.
Senator, will there still be a licensing requirement for those who sell eggs as a part of the cottaging industry, or is all paperwork taken away and they're all free to sell?
If you're considered a large-scale producer, you will fall under the federal food safety rules, so you will obviously have to abide by different laws. But if you're a backyard flock at home, you will not have to have a candling license from the state of Georgia.
Thank you for setting our chicken eggs free.
Yes, ma'am. Thank you. Mr. President, I'll yield the well.
Senators yielded the well. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there objection to agreeing the report of the committee which is favorable to pass the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. The Secretary will unlock the machine. On the passage of the bill, the yeas are 45, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 37th for a motion.
Mr. President, I'd like to move Senate Bill 573 from the table.
Secretary will read the caption to Senate Bill 573.
Senate Bill 573 by Senator Setzler of the 37th and others, a bill to be entitled an act to amend Chapter 2 of Title 21 of the Official Code of Georgia annotated relating to primaries and elections generally so as to provide for the nonpartisan election for county officers and district attorneys in certain counties, to provide for the qualifying for such offices, to provide a definition, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
The senator from the 37th has moved that Senate Bill 573 be removed from the table. Is there objection? Hearing none, Senate Bill 573 is removed from the table. Would the Secretary read the rest of the caption, please?
Senate Bill 573 by Senator Setzler of the 37th and others, a bill to be entitled an act to amend Chapter 2 of Title 21 of the Official Code of Georgia annotated relating to primaries and elections generally so as to provide for the nonpartisan election for county officers and district attorneys in certain counties, to provide for the qualifying for such offices, to provide a definition, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, the Senate Committee on Ethics recommends that this bill do pass. Respectfully submitted, Senator Watson of the 11th District Chairman. Mr. President, minority report has been attached. Mr. President, that completes the order.
Senator from the 6th, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, is it not true that you have to be at your seat to be recognized to be called to the well?
That is in the rules, Senator. That is true. Chair recognizes the senator from the 37th to speak to Senate Bill 573.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I bring today Senate Bill 573, a bill that establishes nonpartisan elections for county commission, DA, solicitor, clerks of court, tax commissioner, and if there's an elected surveyor in counties that have the complexity and size and scale to have eliminated their elected coroner position and instead in placed a medical examiner. As we know, the core metro counties in Atlanta are complex, large. They represent nearly 40% of the state's population, more than half the state's gross domestic product, and essentially form the parts and pieces of a global city. We recognize that over time, cities across our state are nonpartisan because the responsibilities that's really concentrated in the hands, both legislative power, executive power, policing power, and again, these core metro counties have consolidated not only their traditional county powers, but also have county police forces. They have medical examiners that are not under, again, police forces don't fall under the sheriff. Medical examiner functions don't fall under a coroner. They're consolidated under a county commission. And because of the complexity, size, and scale of that, we believe the best approach to this or nonpartisan elections. There are some proven benefits to this we talked about in committee. And Mr. President, would love to hear some debate on this. I'm sure there will be a couple opinions, and glad to take questions as we wrap debate. Thanks, Mr. President.
Chair will recognize the senator from the 6th. What purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Is it not true that the earth just shook because the senator from the 37th got out of the well in less than 2 minutes?
It's a pretty rare occasion there. Yes, sir. Chair recognizes the senator from the 44th to speak to the measure. Senator from the 44th.
Thank you, Mr. President. So that the public understands, at a minimum, even and possibly some members of our chamber, this legislation would use sort of a legal workaround to attempt to make the elections for the district attorneys in Fulton, DeKalb, Cobb, Gwinnett, and Clayton nonpartisan, and all the other DAs, which are 46 other DAs, would stay partisan, and only the 5 would have their elections impacted. And all 5 are Democrats, and all 5 are black women. There are a few problems with this. So, first of all, it would require a constitutional amendment to actually be effectuated. The Georgia Constitution provides that district attorney elections will happen, quote, at the general election, and nonpartisan elections at the general election, end quote. Nonpartisan elections happen on the day of the primaries. So by mandating nonpartisan elections for district attorneys in only some counties, the bill unlawfully changes the election framework mandated by the Constitution. It is settled law that when legislation passed by the General Assembly conflicts with the Georgia Constitution, it's the Georgia Constitution that controls. So the only way to make this change is through a constitutional amendment. Further, there's no rational connection between whether a county has a medical examiner and whether district attorneys should be partisan or nonpartisan. District attorneys are constitutional officers whose authority derives from the state constitution and not from county level status, including medical examiner status. This is why 41, all DAs that responded to inquiries about this, 41 out of the 51 said that every single one of them is opposed. They all agreed that all DA elections should be treated the same. And we had testimony to that effect in committee. 2 of the DAs who would be impacted by this legislation testified against it, as did 2 DAs who would not be impacted by this legislation. Likewise testified against it and said we have to all be treated the same. I didn't hear it just now from the senator from the 37th, but my understanding is that a claim has been made during committee and at other times that these particular 5 DAs are selectively enforcing laws, and that was the stated rationale for the bill. So I'm very happy to report to you that the 2 counties that I represent, DeKalb County and Clayton County, each have a whip-smart, tough district attorney who is laser focused on keeping their community safe and putting away the bad guys. Let me give you a couple statistics from Atlanta. Homicides are down in Atlanta 42% over the last 3 years. Non-fatal shootings are down in 2025, from 2025, 7%. Homicides down 21%. Motor vehicle thefts down 34%. Thefts of items from motor vehicles down 15%. The 5 women being targeted by this legislation are the tip of the spear of law enforcement, putting away the bad guys who commit armed robbery, homicide, human trafficking, assault and battery, and the list goes on and on. Hundreds of criminals are successfully and fiercely prosecuted by these 5 women DAs every day. Frankly, instead of wasting these women's time, these whip-smart, tough women's time by having to run down here with this nonsense bill, we should be thanking them for the work they are doing to keep our communities safe. It is also, finally, very curious to me that the party who says it stands with law enforcement is directly attacking those who have dedicated their lives to it. However, I did see the news that yesterday, another criminal who assaulted police officers on January 6th and received a blanket pardon from President Trump was sentenced to life in prison in Florida for the molestation of several children. And he is just one of at least 35 pardoned January 6th insurrectionists who have been rearrested, charged, or sentenced for other crimes. If we want to make sure law enforcement can do its work in these 5 counties, we need to support all of the district attorneys around this state, not target some and play games with their dedication to their jobs. We should also pass a bill that we have later on the calendar that would provide for a new judge for the Clayton County Judicial Circuit, the circuit that has the highest workload per judge in the state, prosecutes the crimes coming out of Hartsfield-Jackson, and with the World Cup coming, law enforcement in Clayton, including District Attorney Tasha Mosley, needs to work harder than ever to prevent and prosecute all crimes, especially sex trafficking. And that legislation would help move prosecutions expeditiously through Clayton County, helping keep our whole region safe. So if we're going to talk about how we can keep our whole region safe, we need to be talking about measures like that support the hard work of Tasha Mosley, all of the assistant district attorneys in Clayton County, all the judges, instead of, tossing up silly, unconstitutional bills that are an affront to people who have absolutely dedicated their lives, spending every minute putting away the bad guys while we sit in the ivory tower debating silly measures like this. Thank you, Mr. President. I will answer any questions or yield the well.
No questions, Senator.
Thank you. I yield the well, and I urge voting no.
Recognize the senator from the 14th to speak to the measure.
Thank you, Mr. President. I'm going to say the meanest possible thing that I could say about the senator from the 37th bill. This bill is unprincipled. Thank you, Mr. President.
Chair recognizes the senator from the 7th to speak to the measure.
Thank you, thank you, Mr. President. I rise to speak against this bill. I proudly represent Gwinnett County. Senate Bill 573 is not about reform. It is not about fairness, and it is not fooling anybody. As mentioned by the senator from the 44th, this bill targets only 5 counties in Georgia: Cobb, Clayton, DeKalb, Fulton, and Gwinnett. Only 5. Out of 51 district attorneys in this state, this bill singles out just 5 offices and says their elections should be run differently from the other 46. And what do those counties have in common? By an astonishing coincidence, every one of them is led by a black Democratic woman district attorney. So let's stop pretending that this is some neutral exercise in good government. It is a targeted political attack. It is selective, it is deliberate, and yes, it reeks of racial politics. In committee, the author of the bill seemed deeply offended that anyone would notice the obvious. But if this is not about targeting these women, then where is the real explanation? What is the consistent statewide principle? What is the logic that applies in these 5 counties but nowhere else in Georgia? There isn't one. Instead, we got a rambling theory about medical examiners, police departments, county commissioners, coroners, sheriffs, and concerns about partisanship in law enforcement. But none of that explains the basic question before everybody. Why are only these 5 district attorneys being forced into a different kind of election? And while we're at it, what does having a medical examiner have to do with whether a district attorney should be elected on a partisan or nonpartisan ballot? Nothing. It is a weak excuse for a bill with a very obvious target. As mentioned, let's talk about how isolated this bill really is. 41 district attorneys out of 51 responded to a poll on this legislation, and every single one of them opposed it. Every single one. Think about it. In a profession where people disagree on almost everything, they were united on this. All DA elections in Georgia should be treated the same. Not just the metro ones, not just the black women, all of them. That alone should end this debate. But there's more. The bill is supposedly about partisanship in law enforcement. Fine. Then why doesn't it apply statewide? Why is partisanship suddenly an emergency in only 5 metro counties? Why not in other 150 counties in Georgia? Why not in every judicial court? Because this bill is not about principle. It is about power. It is about making it easier for someone who looks like the senator from the 37th to beat someone who looks like Sherry Boston, Fonnie Willis, Tasha Mosley, Patsy Austin Gaston, and Sonia Allen. That is the truth at the center of this bill, and no matter how many procedural excuses get wrapped around it, that is the truth about this bill. This is not about fixing a broken system. This is about punishing people for winning elections, for holding office, and for not looking like the people who used to monopolize power in this state. And beyond all of that, this bill is unconstitutional. The Georgia Constitution says district attorneys are elected at the general election. Nonpartisan elections do not happen at the general election. They happen on the day of primaries. That is a serious constitutional problem. And there's another one. The Constitution prohibits special legislation based on population. This bill may try to disguise what it is doing, but everyone in this chamber can see exactly what it is. Special legislation aimed at a tiny set of counties for naked political purposes. So no, this is not reform. It is selective, it is punitive, and it is likely unconstitutional, and it is an insult to the voters of Cobb, Clayton, DeKalb, Fulton, and Gwinnett County. I urge this body to reject Senate Bill 573. Thank you, and I yield the bell.
Chair recognizes the senator from the 56 to speak to the motion.
Thank you, Mr. President. I want to commend the senator from the 37th for bringing forth this very important piece of legislation. As you all know, my focus is always primarily on public safety. Our 5 largest and most populous counties are where the majority of challenges we face come from due to the density of our population. They're also some of the most municipalized, which means the cities within those counties, which have mostly all nonpartisan elections, are then working with partisan elected officials. In this case, it only makes good common sense to put this forward in order to make sure people are not focusing on the partisanship. They're focusing on doing what we really want to do, which is keeping our citizens safe. And if your main focus is not political, and your main focus is that family in your district, that small business that is concerned about being broken into or taken advantage, to making sure the criminal justice system worked from the time they called 911 to the police officer arriving, for them being prosecuted, for them being judged, and eventually sentenced to a prison sentence, then you will vote for this bill. But don't come up and tell us it's about politics when we're trying to take the politics out of it. Thank you. I yield the well.
Senators yield the well. Senator from the 26th, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Mr. Governor, DA's constitutional officers.
Yes, sir.
Then it would take a 2/3 vote in order to change the Constitution, wouldn't it?
I think this is about whether the election is partisan or nonpartisan. I don't know that it would take a constitutional amendment, but I'm no constitutional scholar for sure.
But the DAs are constitutional officers, aren't they?
That's my understanding. Yes, sir. Thank you. Senator from the 14th, we're hearing a lot from you today. What purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, after the senator from the 56th fulsome explanatory speech, can the chair think of a reason why DAs in any other county should be focused on partisanship and partisan politics instead of the small businesses and citizens in those counties?
Each senator's got the ability to introduce the bill. Let's get this one voted on. Any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. He waves, I think. Oh, he does want to close. I was on a roll, Senator. We got a lot of bills on the list we hope to get to, so let's keep it moving. Thank you.
Thank you, Mr. President. Ladies and gentlemen of the Senate, I want to address some of the questions raised by the minority party and get back to the thrust of this, which is the proposition to take politics out of governance of our core metro area counties. One thing that was raised, and I want to address it because it's not just the members here, it's also the members of the public who are watching this. The idea that we have the contention by the senator from the 42nd that I've said somehow that the DAs in the core metro area are selecting and enforcing our laws. I never said that. Never said that. What we've seen, though, is nationally a trend in metro areas is that there's an increasing prevalence of the selective enforcing of laws by politicized DA offices. She mentioned DA Boston from DeKalb County. I've worked with DA Boston, have tremendous respect for her. As many of you will know, in this talk about this being some attack on DAs of color, DA Boston was the solicitor of DeKalb County before she was the DA. Do you know how she was first made the DA of DeKalb County? She was appointed by Governor Brian Kemp as the district attorney because she does a great job at what she does. I have full confidence that in a nonpartisan election, DA Boston will be reelected again and again and again as long as she chooses to serve in DeKalb County, because she is serving not only at the with the support of a Democrat base, but also the support of Republicans with whom she serves, and I appreciate her service. The contention this is somehow some targeted thing in some counter-partisan way, it's a foolish suggestion. It was raised in committee. It was raised by our members here, but we can't deny that national trends show that with increased partisanship of prosecution, the laws legislatures pass and the safety citizens can have in their own communities is diminished significantly. We've seen that in state by state by state by state where this has happened, and where we see increased partisanship in our elections. The senator from the 44th also raised the prospect that that homicides are down in the city of Atlanta by 42%. I thank her for the statistic. That's absolutely true. and what is true about the governors of the city of Atlanta. The city of Atlanta is governed by a nonpartisan city council that oversees their police department. Nonpartisan leadership in urban areas is the positive good we're trying to create. The circumstances and the statistics the Senator from the 44th shared is exactly why we're doing this bill. Now, there's been some claims about intentions, and this is trying to make this debate more partisan. Everyone has a right to their own opinion. Everyone has a right to their own green and their own red button. Mr. President, we have seen what Atlanta can be. Atlanta's a global city. We have the world's largest airport. We're hosting the World Cup here in a couple of months. We've had the World Series in Cobb County, also in Atlanta. We're a global city with 5.5 million people. The success we've seen in nonpartisan urban governance is a model. I don't have the ability to make that happen in every single corner of this state, but we do have the potential in a community that I represent, community Senator Albers represents, community that many of you represent, to take some of the partisanness out of keeping the seats straight, the streets safe, paving our roads, providing services, and that's exactly what Senate Bill 573 does. It does not insert partisanship into our leadership. It seeks to remove it. Mr. President, I've been thanked by members of our business community, people who vote on both sides of the political spectrum. They say they think this is a good move. I've been thanked by folks in the prosecution community. In fact, I was asked by one of the prosecutors about who I consulted for this. I've consulted retired district attorneys who've run in Democrat constituencies, Republican constituencies. I've talked to senior staffers in current district attorneys' offices who thanked me, encouraged me for this proposal. Mr. President, every member has a right to their own opinion, but the citizens of Georgia need to understand this is no cynical partisan move. This is a move for enforcing our laws, providing government services in the core 5 metro counties. It's for that purpose. I ask your support for Senate Bill 573.
Senator has yielded the well and closed debate. Is there objection to agreeing the report of the committee which is favorable to the passage of the bill? Senator from the 26th, what purpose do you rise?
Mr. President, I ask again, are these constitutional officers? Are these folks we are talking about constitutional officers?
District attorneys are constitutional officers, I think. Yes, sir.
Mr. President, would I be correct in order to change the Constitution, it takes 2/3 vote?
For a constitutional amendment, it does take a 2/3 majority, yes, sir, to change it.
Further parliamentary inquiry.
State your inquiry.
This is a bill to deal with constitutional officers, a regular bill. But isn't it true that district attorneys are constitutional office, which means it would take a constitutional majority to change the Constitution?
I don't know the answer to that for sure. I'm sure it'd be litigated if it does pass and it's unconstitutional. Somebody can challenge it, Senator. All right. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none, and the main question is ordered. Question is on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. The secretary will unlock the machine. Senator from 37, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
To the senator from the 26th question, isn't it true In the Kemp v. Gonzalez case, even though DAs are constitutional officers, these kinds of decisions can be provided for by general law. That's provided to us. Prosecuting Attorney's Council confirmed that. Even though they're constitutional officers, this bill is appropriately framed.
I'm confident you know what you speak. On the passage of the Senate, come to order. Senate will come to order. On the passage of the bill, the yeas are 24 and the nays are 29. This bill, having failed to receive the requisite constitutional majority, is therefore lost. Senator from 37th, what purpose do you rise?
Mr. President, I'd like to serve notice of my intention to call for reconsideration at the appropriate time.
Just pause just a minute. The senator from the 37th has asked for reconsideration. Pursuant to Senate rules, the chair sets the time for reconsideration to be between 6 and 6:15 p.m. today. Senator from the 26th, state your inquiry.
Mr. President, the time for reconsideration, isn't it right now?
No, sir. The time for reconsideration has to be done today because we're on crossover day, but it's set by the chair, and it has to be at least 10 minutes from now, but it can be any time after 10 minutes from now. And it's set by the chair, and I'm the chair at the moment, so I set it between 6 and 6:15 today, which means we're going to be here at least till then, I guess. So,
well, that means you overruling me.
The big chair may overrule me later, but right now it's 6 to 6:15. All right, thank y'all.
The wheels come off every time, every time. State your point of order.
Mr. President, pursuant to Senate Rules 6-7.1, is it not required, since the gentleman served notice, that we vote to allow that reconsideration to take place? While the President does have the ability to set the time, that motion for reconsideration still should be voted on by the body.
You're going to have a chance. You're going to have an opportunity to vote on it, sir. Okay. As the gentleman, as the pro tem just stated, he set the time for approximately between 6 and 6:15. However, it will be up to the chair whether or not that will even happen itself. So that is a temporary time right now. Senator from the 55th, are you asking, your light's on, and you're asking to speak, or you wave? Now I recognize the senator from the 48th.
Welcome back, Mr. President. I ask unanimous consent to lift Senate Bill 587 off the table.
Secretary, read the caption.
Senate Bill 587 by Senator Still of the 48th and others, a bill to be entitled an act to amend Article 1 of Chapter 12 of Title 16 of the Official Code of Georgia annotated relating to general provisions regarding offenses against public health and morals so as to provide for the establishment of an animal cruelty database, to provide for purpose and funding, to require the Prosecuting Attorney's Council of the State of Georgia to create, administer, and maintain such database, to provide for minimum requirements, to provide for reporting and forms, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, the Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th District, Chairman. Mr. President, that completes the order.
Is there objection? Recognize the senator from the 48th.
Thank you, Mr. President. Senate Bill 587. I bring to you today because there are some not great people in this world. Somebody who would be so cruel to a pet that they would be charged and convicted of animal cruelty. You know, in October, just a few months ago, a couple in Statesboro were arrested for cruelty against over 50 animals in what officials called a nightmare situation. In January, a K-9 sheriff's deputy was arrested and booked in the Bullock County Jail on 8 counts of animal cruelty. Last month, 2 suspects were arrested in Fannin County for malnourishment and abuse of a dog. In the state of Georgia, we do not have a way to track these heinous crimes. And so, in coordination with the Prosecuting Attorney's Council, we will be creating and administering and maintaining a statewide database that will be updated at least monthly with those who are convicted or plead guilty of cruelty to animals, so that organizations like our humane societies can check that database and then prevent those people from adopting animals in the future. My good friend, the senator from the 40th, and I worked with Prosecuting Attorney's Council on an amendment that's on your desk right now. And all this does is bring together the criminal code of where this is addressed in 16-12-4. While I did not go to the University of Georgia, I do love dogs. I hope that you will vote with me on this bill, and I'm happy to yield for any questions. So I ask your unanimous favor on Amendment 1. I ask you to please support Senate Bill 587. Let's get back on track, and let's get back to the people's work. Thank you. I yield the well.
Thank you, Senator. Apologize for that. Secretary, read Amendment 1.
Senator Still of the 48th and others offers the following amendment. Amendment 1, amend Senate Bill 587 by inserting after funding on line 4 to require clerks of court to transmit certain conviction and sentencing information to the Prosecuting Attorney's Council of the State of Georgia and for other purposes. Mr. President, that completes the order.
I'm trying to help my old seatmate out, you know. I mean, I spent 10 years beside him. I'm listening. I'm hearing him out, you know. Who has amendment number 1? Oh, it's Senator from the 48th. You offer the amendment? Okay. Is there objection to the amendment? Hearing none, amendment number 1 is added. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill as amended. All those in favor of the bill. Isn't this my wife's bill? Isn't this one she wanted right here? Boy, I tell you what, I don't know how y'all gonna vote, but I'll tell you what, y'all make my life a lot easier if y'all vote right on this thing. So, all those in favor vote yea, all opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 54 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed as amended. Good job, Senator. Recognize the senator from the 6th.
Mr. President, I move that SB 589 be risen from the table.
Secretary, read the caption.
Senate Bill 589 by Senator Brass of the 6th and others, a bill to be entitled an act to amend Part 3 of Article 6 of Chapter 2 of Title 20 of the Official Code of Georgia annotated relating to educational programs under the Quality Basic Education Act so as to revise the date by which a child must attain a certain age to be eligible for enrollment in kindergarten or first grade, to provide for parents and guardians to elect for their children who have attained the age of 4 or 5 to be enrolled in a voluntary pre-kindergarten program provided and operated as part of Georgia's pre-K program, to provide for an effective date and applicability, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none. Secretary, finish the caption.
The Senate Committee on Education and Youth recommends that this bill do pass by substitute. Respectfully submitted, Senator Hickman of the 4th District, Chairman. Mr. President, the Senate Committee on Education and Youth offers the following substitute to Senate Bill 589, a bill to be entitled an act to amend Code Section 20-2-150 relating to eligibility for enrollment, program assignments for students, and student social security numbers so as to provide for parents and guardians to elect for their children who have attained the age of 4 or 5 to be enrolled in a voluntary pre-kindergarten program provided and operated as part of Georgia's pre-K program, to provide for an effective date and applicability, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 6th.
Thank you, Mr. President. This bill is very simple. If a child turns 4 before September 1st, they can attend preschool, pre-K. If they turn 5 before September 1st, they have to go to kindergarten, unless their county allows them to go to pre-K. That's always been the case. But counties, not all counties do it. Not all school systems allow it. This simply takes the power out of the school systems and puts it where it belongs, with the parents. That's it.
Any other senator wish to speak for or against the measure? Recognize the senator from the 33rd. For what purpose you rise?
Thank you, Mr. President. I was going to ask the senator, what was his age when he entered the Senate? I mean, kindergarten.
All right. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. All right. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received a requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 46. Recognize the senator from the 46.
Excuse me, Mr. President, there was a senator from the 37th that was just wearing me out. He hadn't quit talking yet, even after he left the well. If I could, I would ask that Senate Bill 605 be removed from the table.
Senators ask that 605 be removed from the table. Secretary, read the caption.
Senate Bill 605 by Senator Cowsert of the 46 and others, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 15 of the Official Code of Georgia Annotated relating to general provisions regarding prosecuting attorneys so as to provide for additional grounds for discipline of a district attorney or solicitor general or for his or her removal or involuntary retirement from office, to provide for an effective date and applicability, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
Mr. President, the Senate Special Investigations Committee recommends that this bill do pass by substitute. Respectfully submitted, Senator Cowsert of the 46th District Chairman. Mr. President, the Special Committee on Investigations offers the following substitute to Senate Bill 605, a bill to be entitled an act to amend Article 1 of Chapter 18 of Title 15 of the Official Code of Georgia Annotated relating to general provisions regarding prosecuting attorneys so as to provide for additional grounds for discipline of a district attorney or solicitor general or for his or her removal or involuntary retirement for offices and for other purposes.
Recognize the senator from the 46.
Thank you, Mr. President. Senators, this bill comes from the work of the Special Investigative Committee over the last 2 years, where there was quite a bit of evidence presented to us and testimony about conduct of prosecutors and really the lack of public faith in the independence and the impartiality of the prosecuting attorneys in the state. Back in 2023, we passed a bill that set up Prosecuting Attorneys Qualifications Commission to review conduct of prosecutors, both DAs and Solicitor Generals. And that ended up didn't have rules and regulations enacted, and we had to reenact it in 2024. Finally got the rules up and going, and that commission has been active. We learned that over the last couple of years, they have handled somewhere, the number 186 sticks in my mind, but somewhere close to 200 complaints against prosecuting attorneys. Out of those complaints, they have not presented a hearing on any of them after the investigation. Part of the reason is because the areas of conduct that we had defined that were inappropriate, that were subject to sanctions by this commission, were very limited and not particularly clear. They applied to willful misconduct in office, a willful or persistent failure to carry out the duties of your office, conviction of a crime of moral turpitude, or conduct prejudicial to the administration of justice. We learned through the case where Fonnie Willis was removed from the election interference case based on an appearance of impropriety that many of the prosecutors wanted more clearly defined standards of conduct. They wanted more of a bright line rule. Tell us exactly what is not permitted before we're taken off of cases or disciplined in some way. So that's what this bill does, after a lot of collaboration with the District Attorney's organization and also the Solicitor General's organization, and testimony from quite a few district attorneys, including the district attorney from DeKalb County and Clayton County, as to what they agreed would be appropriate actions that should allow discipline against them. So starting on line 25, those are the changes or the added clarifications of conduct that would not be permissible and would subject the prosecutors to some type of sanctions, anywhere from a reprimand to removal from a case to a suspension even. One is a failure to make reasonable efforts to strictly comply with the Crime Victims' Bill of Rights. We have victim rights, and that largely involves notification of the victim that the criminal is being prosecuted, and the various steps in their prosecution, from the arraignment to plea bargains to a plea deal, so that they can be heard. And if a prosecutor doesn't at least make reasonable efforts to comply with this bill, then victims are left behind and are not taken care of. So that's one of the rules. There have been some cases where district attorneys have been challenged, including in my home county of Clark County, for failing to even notify victims when there was a plea bargain made, or there was a trial, or there was a sentencing hearing. They didn't even get a chance, and our DA was sanctioned by the judge for that, but this commission didn't have specific power to do that. The original version of this said that they had to strictly comply with the Crime Victims' Bill of Rights, but after input from the district attorneys and testimony from them, we changed that to failure to make reasonable efforts. Because sometimes you're unable to reach the victim if they've moved and didn't tell you their address or whatever. Same thing in line 27, failure to make reasonable efforts to comply with essentially open records laws. Again, we've had a couple of DAs that received open records requests and simply ignored them, refused to respond to them, said they were constitutional officers not subject to them. Court of Appeals has made it clear they are subject to those, so we thought it would be good to put that in this compliance. Our prosecutors need to be transparent. Our law requires them to be. The courts say it applies to them, so they must make reasonable efforts to comply with our open records laws. The next one is knowingly authorizing or making a decision based on factors that have been outlined at a different place within the code section. This was initially saying failure to be impartial, and after some discussion, we ended up going ahead and citing another part of the law that says what this applies to. It can be an undue bias or prejudice against the accused, an undisclosed financial interest in the outcome of the case, an undisclosed conflict of interest, factors that are completely unrelated to the duties of the prosecution, or a stated policy, written or otherwise, which demonstrates that the district attorney or solicitor general categorically refuses to prosecute any offense or offenses of which he or she is required by law to prosecute. These factors identified there were put into the code section with the consent and agreement of the prosecuting attorney, so it's something they're already required to do. But we never put in there that you could be sanctioned or disciplined for failure to follow the other part of the statute, so this code section clarifies that. And finally, we say failure to make reasonable efforts to comply with a code section that relates to discovery in criminal procedure. When you're prosecuting a case, the prosecuting attorney has an obligation to provide the accused person with any evidence that we call exculpatory that might prove their innocence. You can't hide evidence that helps the defendant. There's a code section that prevents that, so we say they must at least make reasonable efforts to comply with that discovery provision that's in the law. And then the next one is a catch-all that they have to follow the rules of professional conduct that all attorneys have to follow, and it specifically mentions Rule 3.8, which is a rule of the State Bar of Georgia that applies solely to prosecuting attorneys. And it has things in it like you must know that your case has, or reasonably believe that it has probable cause. You've got to disclose evidence to the other side. You're not supposed to litigate your case in the press or make extrajudicial comments that might heap scorn upon the defendant before they have a chance to have their trial. This is just codifying what is already the law or the rules of professional conduct, making it clear that the prosecuting attorney's commission has the ability to sanction folks for failing to follow these rules. Because right now the state bar can't give them any kind of sanctions other than a reprimand or anywhere up to disbarment, but this gives the appropriate body the power to do that. I think it's a lot of conversation and input from all different types of prosecutors, a lot of testimony over a couple of hearings, and it makes sense. Helps us restore the public's confidence in our judicial system, particularly the criminal justice system, to know you're being treated fairly and ethically and honestly by the prosecuting attorneys. Happy to answer any questions or yield the well.
You do have a couple questions, Senator. I recognize
Thank
Senator
you.
from the 26th. You do have a couple questions, Senator. I'm sorry.
Sure.
Thank you, Mr. President. The gentleman will yield.
I yield.
I don't want to be presumptive, but as I look at this bill and the explanation, you all carried out a investigative review of Fani Willis prosecuting the president. And to me, what I see in here, now I could be wrong, I'm not a lawyer, but what I see is the investigative report in this bill based on your investigation of Fani Willis prosecuting the president.
Senator, I know it doesn't happen much, but you are wrong. This is not aimed at Fani Willis in any way. As a matter of fact, it's responsive to some of the concerns that she raised. Our committee has taken no action whatsoever against her. We have no jurisdiction or authority over her. She was removed from a case by a Superior Court judge, appealed that, and it was upheld by the Court of Appeals and the Supreme Court that her behavior was improper. And they used the phrase, appearance of impropriety, without specifying particular conduct that she had done. And that was her beef. And other prosecutors tell us the rules. Don't just say you don't like what I did and it appears that I did something improper. What's the bright line rule? What is the conduct that I did that was inappropriate? So this is to help her in the future, that there has to be a bright line rule, a clear guardrail of what's permissible. So this is in no way any action against her, and it applies to all prosecuting attorneys.
You have one more question, Senator. I recognize Senator from the 41st.
Thank you, Mr. President. Does the Senator yield?
I yield.
Senator, can you tell me the difference between strictly comply, as found on line 25, and comply, which is found throughout the rest of the bill?
Say that again. Strictly comply on line 25 says failure to make reasonable efforts to strictly comply.
Yes. So what's the difference between strictly complying and complying? How are you making a distinction between those two things?
The code as written here doesn't even require you to comply. At the response of Tasha Mosley, or the input from Sherry Boston and Tasha Mosley from Clayton County and DeKalb, they said, what if we're trying to comply and we simply drop the ball because of our volume or because of a loss of an address or some clerical mistake? And so at their request, I changed it from failure to comply or failure to completely or strictly comply to failure to make reasonable efforts to comply. But surely every district attorney ought to make reasonable efforts to comply with the law. We passed the Victim Bill of Rights, we passed the open records laws, and we expect the people that are enforcing the laws to follow them or at least make reasonable efforts to.
Does the Senator further yield?
I'll be glad to.
Would you read aloud line 25? Because
I'm glad to.
I think that you believe, isn't it not true that you think strictly has been removed, but strictly is still there?
I amended the original bill to this substitute in response to concerns raised by district attorneys that they may not be able to or willing to strictly comply with the Crime Victims Bill Act. I'll read it to you what it now says. Failure to make reasonable efforts to strictly comply, and then it says the Crime Victims Bill of Rights. So that was in direct response to make sure that no DA was inadvertently disciplined in some way when they had made reasonable efforts and done their best to comply with the laws that apply to them.
Do you further yield?
Yes?
Isn't it true that the DA from DeKalb County remains unsettled by the use of the word strictly?
I don't think so. I think that the testimony you heard in committee was before they read the substitute. And I say they, she and Tasha Mosley, who are very fine district attorneys, they were on the phone and texting with me till about 11:15 the night before this vote. And I told them I was going to take their concerns into account, and I did. And when you heard their testimony in committee, I said, wait a second, make sure you read this committee substitute, and then let's see if you still have a problem. And I think once they read it, that I had softened it to make reasonable efforts. I believe they were okay with it. If not, they surely ought to be.
No further questions, Senator.
All right. I yield the will.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objections to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objections to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 34 and the nays are 18. This bill, having received requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 42nd.
Mr. President, I move that Senate Bill 482 be removed from the table.
Secretary, read the caption.
Senate Bill 482 by Senator Strickland of the 42nd and others, a bill to be entitled an act to amend Chapter 1 of Title 35 of the Official Code of Georgia annotated relating to general provisions regarding law enforcement officers and agencies so as to require persons requesting booking photographs to provide the first and last names of the individuals in the photographs, to require requests for booking photographs to be made as separate requests, to provide for related matters, to provide for an effective date and applicability, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption. Who do you have with you here today, Senator? Is that the First Lady of the 42nd there with you? It is. Well, let's give the First Lady right there.
The First Lady of the 42nd, the former First Lady of the 17th, now the 42nd.
And you got a house number too now. What was that house number? You were the house member.
Former First Lady of House District 111.
Okay, all right. I'll tell you. Yeah. Good to have you here, Lindsay. It's always a pleasure. Go ahead, Secretary.
Mr. President, the Senate Committee on Public Safety recommends that this bill do pass by substitute. Respectfully submitted, Senator John Albers, the 52nd District Chairman. Mr. President, the Senate Committee on Public Safety offers the following substitute to Senate Bill 482, a bill to be entitled an act to amend Titles 35 and 50 of the Official Code of Georgia annotated relating to law enforcement officers and agencies and state government, respectively, so as to require persons requesting booking photographs or law enforcement videos to provide the first and last names of the individuals in such photographs or videos and for other purposes.
Mr. President, Strickland and others offer the first.
Mr. President, Senator Strickland of the 42nd and others offers the following amendment. Amendment 1, amend Senate Bill 482 by striking lines 21 and 22 and inserting in lieu thereof the following: except for requests by the persons or persons depicted or requests by the attorney or other designated agent of such person or persons depicted, requests for booking photographs or law enforcement video shall be made in person as separate requests for each booking photograph or law enforcement video. Requests for booking photographs or law enforcement videos by the person or persons depicted or requests by the attorney or other designated agent of such person or persons depicted shall be made in writing pursuant to Article 4 of Chapter 15 of Title 50.
Mr. President, Senator Robertson of the 29th offers the second.
Mr. President, Senators Robertson of the 29th and others offers the following amendment. Amendment 2, amend the Senate Committee on Public Safety substitute to Senate Bill 482 by inserting after changes on line 6 to provide for the public disclosure of certain records of the General Assembly, to provide for application, to provide for construction, by replacing line 38 with the following. Said chapter is further amended by adding a new code section to read as follows: 50-18-79. If any claim of an unlawful employment practice made against the General Assembly, the House of Representatives, the Senate, or any member, office, or employee thereof, including but not limited to a claim of sexual harassment, discriminatory harassment, discrimination, or retaliation, is resolved in whole or in part by a settlement agreement, a memorandum of agreement or understanding, or other similar document, however denominated. Such agreement shall be subject to public disclosure within the claimant's identity redacted. For purposes of this subsection exclusively, the General Assembly shall be an agency. This subsection shall be applied retroactively and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 42nd.
Mr. President, we just had to make certain that the First Lady didn't go downstairs to the second floor and try to qualify for anything today, but the time has passed, so we're safe now. She would be.
She'd be a good
She
one.
fills that seat well. Members of the Senate, I bring to you Senate Bill 482. What this bill says is someone wants to request an arrest image or a law enforcement video, they must request that image or video in person, identify the individual they want the image of, and sign an affidavit, confirm they won't use that image or video, post it online, and charge somebody for having it taken down. Mugshots and body cam videos are not entertainment, and folks should not be making money by posting these images or videos online or other publications in our state. With this bill, we're making certain that images and videos remain open to the public and the legitimate press, while letting those in the mugshot business know we aren't going to let you make a living off of harassing our sheriffs or other law enforcement, and by trying those charged with crimes in the court of public opinion. And that is the underlying bill, Mr. President. There are two amendments. Amendment 1 that I'm bringing, which clarifies something that I missed when we drafted the bill, that if it's your image, if it's your mugshot, or if you're in the body cam video, you can still request that directly without going through this process here. There's Amendment 2 from the Senator from the 29th that he will explain when he comes up, which also is a friendly amendment on this bill as well. I'll be happy to take any questions.
You have no questions.
I ask for your support of Senate Bill 482 and both amendments.
Recognize the Senator from the 29th to speak to his amendment.
Thank you, Mr. President. I'd like to thank the Senator from the 42nd for accepting this as a friendly amendment from the 42nd and all the other districts he has represented since being in this building. It's really simple. I presented a piece of legislation earlier that talked about how law enforcement and teachers and clergy need to be dealt with when they choose to be perpetrators of sexual harassment, sexual abuse, or anything else. All this amendment does is bring that same standard upon anyone that serves in this building. If you go to Washington, D.C., if you look at what happened today when somebody tried to bring accountability to Congress and hold them to that standard, it was voted down by vast majority of the people that serve in Congress. Let us be better than they are. Let us be willing to have ourselves looked at. All this does is if you have been accused of, if you have been found to be guilty of any of these actions, if you reach a settlement because of your misconduct, if the courts determine you were wrong because of your conduct, that information should be available to the public, should they ask. And with that, Mr. President, I yield the well.
Would any other senator wish to speak on the measure? Hearing none. So we'll take up amendment number 1, authored by the senator from the 42nd, the author of the bill. Is there objection to amendment number 1? By objection, amendment number 1 is applied. Senator from the 55th, for what purpose do you rise?
Parliamentary inquiry, Mr.
State your inquiry.
On the amendment by the distinguished gentleman 29, he said if you were found guilty, if you were found liable, I don't see that language in here. I see that if there is a settlement agreement, it doesn't speak to the guilt or innocence. Is that not true?
Senator, that means something you need to walk over there and talk to your colleague about there. Question is on amendment number 2. Is there objection to amendment number 2? Without objection, amendment number 2 is adopted. The question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 53, the nays are 0. And this bill, having received requisite constitutional majority, is therefore passed by substitute. Recognize the majority leader for a motion.
Mr. President, I ask unanimous consent to take Senate Bill 540 from the table.
Senator's request. Secretary, read the caption.
Senate Bill 540 by Senators Anna Vitarte of the 31st and others, a bill to be entitled an act to amend Chapter 5 of Title 39 of the Official Code of Georgia annotated relating to online internet safety so as to require certain disclosures related to controversial AI services, to require the operators of controversial AI services to take steps to limit certain actions related to minors by such systems, to require operators to provide certain privacy tools to users, to require operators to adopt a protocol for a conversational AI services response to suicidal ideation or self-harm, to provide for enforcement by the Attorney General, to provide for exceptions, to provide for definitions, to provide for related matters, to repeal conflicting laws for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none. Secretary, finish the caption.
Mr. President, the Senate Committee on Children and Families recommends that this bill do pass by substitute. Respectfully submitted, Senator Kirkpatrick of the 32nd District, Chairman.
Recognize the Majority Leader.
Mr. President, the Senate Committee on Children and Families offers the following substitute to Senate Bill 540, a bill to be entitled an act to amend Chapter 5 of Title 39 of the Official Code of Georgia annotated relating to online internet safety so as to require certain disclosures related to controversial AI services and for other purposes. Mr. President, Amendment number one by Senator Setzler of the 37th and others to amend Senate Bill 540 by inserting after line 83 the following. Nothing in this code section shall be constructed to limit or preclude any other available remedy at law or equity. Mr. President, Senator Hatchett of the 50th and others offers the following amendment. Amendment 2, amend the Senate Committee on Children and Families substitute to Senate Bill 540 by striking lines 30 and 31 by redesignating subparagraphs C, D, E, and F on lines 32 through 36 as B, C, D, and E, respectively, by inserting between lines 70 and 71 the following. Before allowing access to a conversational AI services that could provide synthetic content containing sexually explicit content, an operator shall use a responsible age verification method and for other purposes. Mr. President, that completes the order.
Thank you, Mr. President. Senate Bill 540, presenting to y'all today. Artificial intelligence is rapidly transforming our world. It's already helping doctors detect diseases earlier, improving productivity across our workforce, and giving small business powerful tools that once only large corporations could afford. It's also becoming increasingly important to our national defense and economic competitiveness. AI has become may very well become the most powerful technology in the 21st century. The United States must lead in this space, and we must ensure that American innovation continues to outpace our foreign adversaries. President Trump has made it clear during his administration and again in his recent executive action on AI. The president has emphasized winning the AI global race is critical to our economic strength and our national security. At the same time, his executive order also recognizes that states have an important role to play in establishing responsible guardrails, particularly when it comes to promoting children online. Senate Bill 540 aligns with that agenda. It allows innovation to continue, but it ensures that we are addressing the real risks that emerging AI technologies can pose to our children. Across the country, we are seeing the rapid rise of conversational AI systems designated to simulate human interactions. For many adults, these tools can be useful and productive, but for children and teenagers, they present real and growing risks. Recent studies show that nearly 2/3 of teenagers are already using an AI chatbot, and more than half of them are turning to these systems for emotional support. These systems are not neutral. They are machines specifically designed to maximize engagement. They are programmed to validate and reinforce user behavior in order to keep people interacting with them for a longer period of time. For developing minds, that dynamic can be especially dangerous. We have already seen troubling examples. AI chatbots have simulated romantic relationships with minors and in some cases have encouraged harmful behavior or failed to respond appropriately when young users express thoughts of harm, self-harm, or suicide. That is completely unacceptable. Senate Bill 540 establishes common sense guardrails to ensure that these technologies develop in a way that protects Georgia's children. The bill prohibits sexually explicit interactions between AI systems and minors and bans AI from simulating romantic relationships with children and requires operators to maintain procedures that direct users expressing suicidal thoughts to proper crisis resources. Second, it requires conversational AI programs to clearly disclose when a user is interacting with AI rather than a real human being. The bill also requires AI platforms to provide parental controls tools that parents and not algorithms have the final say over their children that interact with these systems. These are simple, reasonable protections. They do not stop innovation. They do not hinder responsible companies that are building the next generation of technology. Instead, they ensure that AI becomes the more integrated into our daily lives. Our children are not exposed to preventable harm. Georgia should absolutely remain an innovation leader in this space. AI will continue to shape our economy, strengthen our national security, and create opportunities for the next generation. But leadership in technology must also mean leadership in responsibility. Senate Bill 540 supports innovation while protecting Georgia's families and ensuring that our children are not exploited in a world that is changing faster than any of us could have imagined. I respectfully ask for your consideration favorably of this bill. You will have on your desk one amendment from the senator from the 37th that is friendly, and also an amendment from the senator from the 50th, which is also friendly, and I'll let them present their own amendments. With that, Mr. President, I'll take one or two questions.
You do not have any questions. Yeah.
Thank you, Mr. President. Please vote green.
Recognize the senator from the 40th.
Thank you, Mr. President. I rise in support of Senate Bill 540. It's an important first step in taking action to keep our kids safe online. This has been an important topic for me. I co-chaired a study committee on this during the interim with the senator from the 48th, and I wrote the resolution for the study committee because my kids were in about 8th grade when pretty much all kids started having smartphones. And I could see immediately that this phone was changing them. But there was no kind of collective support for any limitations at that time. And so my voice of concern was kind of the lost voice in the wilderness at that point. These were shiny new objects. The teachers were excited about them. They wanted to use the phones, teach the kids how to do research. We even had a teacher who required my child to open an Instagram account in order to complete an assignment. So it really was a different day. I had concerns, but no one was hearing those concerns. So I have been waiting literally 10 years for this moment. I have been waiting for millennials to have children so that you would be worried about your children along with me and how I was worried about my children. I saw kids getting harmed. Early exposure, just for kids of my friends, early exposure to pornography that was experienced as traumatic to the children, content that developed eating disorders. I saw it happening all around me, but it's taken like 10 years to collect enough data to really know as much as we can that these phones were causing anxiety and depression in our young people. And then about 2 years ago, an author wrote a book, Jonathan Haidt, wrote the book, The Anxious Generation. I'm sure some of you have read it. When I read it, it was like, yes, finally, somebody really gets it. And someone has expressed that. And that book has lit a fire in our country. And there has been so much activism since then. In fact, members of the Anxious Generation team were very helpful in providing testimony to our study committee. Just this week, the team of the Anxious Generation released something called a Childhood Index. It's a first of its kind ranking of all 50 states on how well tech laws and policies in each state support healthy, flourishing childhoods on and offline. And there are 2 states that got the top ranking, New York and Utah. But there were 6 states that got the Rising Star status, which was the second ranking, and I am proud to say that Georgia was among them. And I'm going to read to you why Georgia was ranked one of the Rising Stars, because I think you will be proud. One in the green category was that Georgia has a reasonable childhood independence law that helps protect families from unreasonable charges of neglect. We got a green status for that. We also got a green status for mandating bell-to-bell phone-free schools for K through 8. Y'all voted on that last year, and I'm hoping that this year you'll have the opportunity to extend it to high school. Then in terms of the yellow category, we got points for a bill that we all voted on, Senate Bill 351, a couple years ago, which requires parental consent for minors under 16 to create social media accounts. This has been challenged in the courts, and it's in the courts right now, but we did pass that law. And then also in the yellow category is the work of our study committee that we did during the interim, in that it created a comprehensive blueprint for where we go from now in passing legislation to protect our kids. There's a lot more we can do, but Senate Bill 540 with its amendments is a very good first step. Things have gotten even worse online for kids since my kids were young because of AI and these companion chatbots that are being rolled out without any care and concern about risks. We heard torturous testimony in our study committee from families whose kids started interacting with chatbots. One kid started interacting with a chatbot because he was using it to do his homework. And this chatbot, it like acted like it was in love with this kid. And the kid reciprocated and fell in love with this chatbot. And the chatbot ultimately talked the child into killing himself. And that mother testified to our committee. Y'all, these chatbots are so incredibly dangerous for our kids. 75% of our kids have used them, but when you mention them to parents, a lot of parents don't even know what they are. So that's why action that we're taking on Senate Bill 540 is so important. It is just a first step, though. There's more work for us to do. Particularly, we need to do more to help our parents keep their kids safe online. Parental controls are out there, but they're incredibly difficult and time-consuming to use. And we need to deal with the addictive nature of social media, which 40 of you signed my bill that regulates manipulative, addictive design in social media and gaming. So we need to come back next year and deal with this more fully. But Senate Bill 540 is a really good first step, and I urge your support. Thank you.
Does any other senator wish to speak for or against the measure? We have a late arriving amendment. Okay. Stand by. Secretary, just read the amendment whenever you have it ready.
Senator Jackson of the 41st offers Amendment 2A to amend Amendment 2 to Senate Bill 540 by striking on lines 16 and 17 as G, H, I, J, and K respectively, and replacing it with and redesignating accordingly. Mr. President, that completes the order.
Recognize the senator from the 41st. Speak to the amendment. You waive? Okay. All right, so we're going to take them up in reverse order here. We'll start with Amendment number 2A, authored by the senator from the 41st. Is there objection to 2A? Hearing none, 2A is amended. Now on to Amendment number 2. Is there objection to Amendment number 2? No objection. And now Amendment 1, authored by the senator from the 37th. Is there objection to Amendment 1? Without objection, Amendment 1 is added. Questions on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 54, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 25th.
Mr. President, I move that we pull Senate Bill 454 from the table, please.
Secretary, read the caption.
Senate Bill 454 by Senator Williams of the 25th and others, a bill to be entitled an act to amend Chapter 2 of Title 25 of the Official Code of Georgia annotated relating to regulation of fire and other hazards to persons and property generally, so as to authorize the use of temporary door locking devices in public buildings during certain emergency situations, to provide for guidelines for use of such devices, to provide for rules and regulations, to provide for definitions, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary finish the caption.
Mr. President, the Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th District Chairman. Mr. President, that completes the order.
Recognize the senator from the 25th. Speak to the bill.
Thank you, Mr. President. You know, we all have one precious thing in our life, and that's our children. And when we take our children or send our children to school in the morning, we hope and pray they come home safe that day. And this is what Senate Bill 454 is about. It's a measure focused on strengthening school safety while maintaining the highest standards of fire safety. This legislation allows for the limited use of temporary door locking devices in public buildings, particularly schools, only during emergency active threat situations or drills, such as lockdowns or shelter-in-place events. The Department of Insurance is supportive. It does not legislate one particular product over another one. Staff and first responders will be trained on the device before it is used. You cannot trap anyone in a room with any version of these devices. They are only used to keep bad actors out. It is not different from locking a door with the door handle from the inside. All you do is twist the handle and exit. A barricade device that just slips out and you exit. If there's no questions, I'll be glad to yield the wheel, and I'll ask for your favorable consideration. For the children, Mr. President, thank you.
No questions, Senator. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Is there objection to agreeing the report of the committee which is favorable to pass the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 51 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 30th for a motion.
Mr. President, I ask for unanimous consent to remove Senate Bill 594 from the table.
Secretary will read the caption.
Senate Bill 594 by Senators Bearden of the 30th and others, a bill to be entitled an act to amend Part 4 of Article 6 of Chapter 9 of Title 16 of the Official Code of Georgia annotated relating to internet and email fraud so as to establish the criminal offense of digital identity fraud, to provide for criminal penalties, to require social media platforms to evaluate claims of digital identity fraud, to provide for civil penalties, to provide for enforcement, to provide for a cause of action and damages, to provide for definitions, to provide for related matters, to provide for an effective date and applicability, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Senator from the 30th District has moved that Senate Bill 594 be removed from the table. Is there objection? Hear none. Senate Bill 594 is removed from the table. Secretary will finish the caption.
Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 42nd District, Chairman. Mr. President, that completes the order.
I recognize the senator from the 30th to speak to Senate Bill 594.
Thank you, Mr. President. I rise today to present Senate Bill 594, before I present the bill, I really need to lay the foundation out to why this bill is here. One of my constituents back home was going through a very complicated pregnancy where they did not think the baby would even make it to birth. So she did like many other families did in crisis. She turned to social media to make sure her friends and loved ones could keep updated with the progress without having to answer the same questions time and time again. Pretty much by a miracle, her baby Landry, was born. And for the next 4 months, baby Landry fought complications. But exactly 4 months to the day she was born, she passed away. Just days later, the mother discovered a fraudulent social media post using her personal photos, videos of the family, and Landry. The post claimed baby Landry was still alive and desperately needed money to be saved. For weeks, she contacted the platform and requested the fraudulent content to be removed. The platform responded that the post did not violate the terms of service. And during the portion that she had to fill out, it even requested that she provides a death certificate of her child to prove that the baby has passed. She went through that process. The fraudulent posts remain active. She then filed a police report with her local sheriff's office. Law enforcement opened an active investigation but lacked the authority or the mechanism to force the platform to remove the content. This is where I publicly want to say thank you to someone that don't hear thank you very often, and that's our media, specifically Savannah Levins of 11 Alive. When she got involved, she was able to get the posts taken down. As copycat posts showed up, she was able to get those taken down. While I greatly appreciate the work of Ms. Levins, I have a major issue when a victim can't get a fraudulent post removed. Law enforcement can't get a fraudulent post taken down, but it takes the media to have a fraudulent post removed. So what does Senate Bill 594 do? It creates a new felony offense of digital identity fraud. A person commits the offense of digital identity fraud when using someone's personal images, videos, or identifying information online to deceive others for financial gain or other unlawful purposes. It also establishes a clear process for victims to remove the fraudulent content. The victim can submit a process or a request to the social media platform. The platform must review and make a determination within 72 hours, excluding weekends, if the content is fraudulent. But then if the platform, upon receiving an active police incident report from Georgia law enforcement confirming fraudulent activity, the social media platform must restrict public access to the content or activity within 48 hours, again excluding the weekends. Violations carry a $50,000 civil fine per incident. The prosecuting attorney or attorney general is authorized to enforce these civil penalties. And finally, a social media platform's violation of these requirements create a private right of action, allowing the victim to pursue civil remedies directly. Folks, it's time to give victims a real voice, a real recourse, and platforms must be held to a basic standard of responsibility when criminals exploit our citizens and especially our children on their sites. Senate Bill 94 protects our citizens, hopefully deters this cruel form of fraud, and ensure platforms act swiftly. I ask respectfully for your favorable consideration on Senate Bill 594, and let's do the right thing for our families. And Mr. President, I yield the well if there's no questions.
No questions, Senator.
Thank you very much.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Is there objection to agreeing the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill. All those in favor will vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 50, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 45th for a motion.
I request that Senate Bill 498 be lifted from the table.
Secretary, read the caption.
Senate Bill 498 by Senators Dixon of the 45th and others, a bill to be entitled an act to amend Article 31B of Chapter 2 of Title 20 of the OCGA relating to charter school capital finance so as to establish the Georgia Charter Schools Facilities Authority for the purpose of enabling charter schools to obtain revolving loan funds and other public financing assistance for purposes of constructing, renovating, and rehabilitating educational facilities for much schools. To amend Article 2 of Chapter 17 of Title 50 of the OCGA, the Georgia State Financing and Investment Commission Act, so as to provide for the issuance of general obligation bonds by the Georgia State Financing and Investment Commission, to provide for educational facilities for charter schools, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Senator from the 45th has moved Senate Bill 498 be removed from the table. Is there objection? Hearing none, Senate Bill 498 is removed from the table. The Secretary will read the remaining caption.
Mr. President, the Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffstetler of the 52nd District, Chairman. Mr. President, the Senate Committee on Finance offers the following substitute to Senate Bill 498, a bill to be entitled an act to amend Article 31B of Chapter 2 of Title 20 of the Official Code of Georgia annotated relating to charter school capital finance so as to establish the Charter School Facilities Authority for the purpose of enabling charter schools to obtain revolving loan funds and other public financing assistance for purposes of constructing, renovating, and rehabilitating educational facilities for such school and for other purposes. Mr. President, a fiscal note is attached. Mr. President, that completes the order.
I recognize the senator from the 45th to speak to Senate Bill 498.
Thank you, Mr. President. Senate colleagues, I bring Senate Bill 498 before you today. It addresses a significant challenge faced by Georgia's charter schools when financing their facilities. It creates the Georgia Charter School Facilities Authority, and it establishes its ability to issue revolving loans and administer other funds to support charter schools with capital projects. It caps the loan amounts at 20% of the total project, and it limits the term of the loan to the length of the charter school's charter. This bill provides charter schools with increased access to affordable capital and ensures more dollars are spent on kids rather than buildings. Mr. President, I'd be happy to answer any questions, or I'll yield the well.
No questions, Senator.
Thank you.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing the report of the committee which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. The secretary will unlock the machine. Senator from the 13th, what purpose do you rise? Senator from the 13th, your light's on. He waves. On the passage of the bill, the yeas are 49, the nays are 3. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 29th for a motion.
Mr. President, I ask for unanimous consent to take Senate Bill 501 off the table.
Secretary, read the caption.
Senate Bill 501 by Senators Robertson of the 29th and others, a bill to be entitled an act to amend Titles 8 and 25 of the Official Code of Georgia annotated relating to buildings and housing and fire protection and safety respectively so as to improve government efficiency by updating provisions to the Office of the Safety Fire Commissioner to provide for an effective date, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Senator from the 29th has moved that Senate Bill 501 be removed from the table. Is there objection? Without objection, Senate Bill 501 is removed from the table. Secretary will read the caption to Senate Bill 501.
Mr. President, the Senate Committee on Public Safety recommends that this bill do pass by committee substitute. Respectfully submitted, Senator Albers of the 56th District Chairman. Mr. President, the Senate Committee on Public Safety offers the following substitute to Senate Bill 501, a bill to be entitled an act to amend Titles 8 and 25 of the Official Code of Georgia annotated relating to buildings and housing and fire protection and safety, respectively, so as to improve government efficiency by updating provisions of the Office of the Safety of Fire Commissioner to provide for procedures for rules, promulgation, hearings, and appeals, to provide for the appointment of a Deputy Commissioner of Safety Fire, to provide for such positions, duties, and powers, to provide for the payment of expenses of certain employees and for other purposes. Mr. President, that completes the order.
I recognize the senator from the 29th to speak to Senate Bill 501.
Thank you, Mr. President. Colleagues, this is a legislation brought to us by our insurance commissioner, who is, as we know, also over our fire safety for the state of Georgia. What this legislation does is it establishes a consistent process for hearing across the agency to conform with modern legal processes. Those wishing to appeal a decision of the office must first request a hearing from the commissioner, and if the decision is upheld, they can petition for review in the Superior Court of Fulton County. It establishes an appeal mechanism for those aggrieved or adversely affected by a final ruling of a local governing authority on a building permit. Appeals will go before a board made up of local authorities, licensed contractors, and members of OCISF to determine if the local authority's final ruling will be upheld, modified, or reversed. It provides oversight for over-deputized personnel to ensure deputized local fire marshals and state inspectors are in compliance with administrative and operational procedures. It authorizes the commissioner to issue an immediate evacuation order from a building or structure that presents an imminent life safety hazard. It enhances fire fatality investigation and reporting by requiring coroners and medical examiners to report all fire fatalities to the agency and prevents them from moving fire-related decedents until authorized by personnel with the state fire marshal. It amends punishments for violating Title 25, and modernizes fees and fines for not having working smoke detectors in dwellings, and increases reinspection fees for manufactured housing certificates. This helps cut down on excessive reinspections and using OCI staff as quality control. I would ask that for a positive vote on this, as it makes our state safer by providing the tools needed for our local fire safety division of the Office of Insurance Commissioner and Safety Fire. And with that, I will yield unless there are any questions.
No questions, Senator. Does any other senator wish to speak for or against the measure? The chair hears none. Is there objection to the previous question being ordered? The chair hears none, and the previous question is ordered. The question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection agreeing the report of the committee, which is favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? The chair hears none, and the main question is ordered. Question on the passage of the bill by substitute. All those in favor vote yea. Opposed, nay. The secretary will unlock the machine. On the passage of the bill, the yeas are 51 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Chair recognizes the senator from the 54th for a motion.
Yes, Mr. President, I ask for unanimous consent to remove Senate Bill 485 from the table.
Secretary will read the caption of Senate Bill 485.
Senate Bill 485 by Senators Payne of the 54th and others, a bill to be entitled an act to amend Article 1 of Chapter 10A of Title 43 of the Official Code of Georgia annotated relating to examination regarding professional counselors, social workers, and marriage and family therapists so as to authorize applicants for a license in social work enrolled in a master's degree program to take the master's social work licensing examination in their final semester of the program, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Are you running again?
Senator from the 54th has moved that Senate Bill 485 be removed from the table. Is there objection? Hearing none, Senate Bill 485 is removed from the table. The Secretary will read the remaining caption.
Mr. President, the Senate Committee on Regulated Industries and Utilities recommend that this bill do pass. Respectfully submitted, Senator Calzert of the 46th District, Chairman. Mr. President, that completes the order.
I recognize the senator from the 54th to speak to Senate Bill 485.
Thank you, Mr. President. Because we got a lot of good Senate bills and we need to get moved, I'm going to be quick. This better serves Georgia's need for mental health professionals. What this bill simply does is allow students from their final semester of school, a Master of Social Work program, to sit for their licensure exam before they graduate in their final semester of school. Mr. President, any questions? I will yield the will.
No questions, Senator. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection agreeing the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. The Secretary will unlock the machine. On the passage of the bill, the yeas are 48 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Chair recognizes the senator from the 25th.
Thank you, Mr. President. I ask for unanimous consent to pull Senate Bill 586 from the table.
Senator from the 25th has moved that Senate Bill 586 be removed from the table. Secretary, read the caption.
Senate Bill 586 by Senator Williams of the 25th and others, a bill to be entitled an act to amend Code Section 16-11-107 of the Official Code of Georgia annotated relating to interfering with, harming of, or aggravated harming of a public safety animal or search and rescue animal so as to provide for accommodations of public safety animals and search and rescue animals that are injured or killed in the line of duty, to provide for related matters, to provide a short title, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection to the motion? Hearing none, Senate Bill 586 is removed from the table. Secretary will read the remaining caption.
Mr. President, the Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th District Chairman. Mr. President, that completes the order.
I recognize the senator from the 25th to speak to the bill.
Thank you, Mr. President. This is something that I think is very much needed. This bill is in honor of our public safety animal or search and rescue animals, so as to provide for accommodations of public safety animals and search and rescue animals that are injured or killed in the line of duty. And the Commissioner of Public Safety shall be authorized to issue commendations for heroism to any public safety animal or search and rescue animal that is injured or killed in the line of duty. And that's all this bill is, recognizing our four-legged heroes.
All right.
I ask
Senator,
for
no
your
questions.
favorable consideration. I'll yield the will. Thank you.
No questions. No questions. Thank you, Senator. Would any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor of the bill will vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 51, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 51st, from Lumpkin County, Georgia.
The gold city of
the gold capital of Georgia.
Mr. President, I ask for unanimous consent to remove Senate Bill 465 from the table.
Secretary, read the caption.
Senate Bill 465 by Senator Gooch of the 51st and others, a bill to be entitled an act to amend Article 2 of Chapter 7 of Title 48 of the Official Code of Georgia annotated relating to imposition, rate, computation, exemptions, and credits relative to income taxes so as to disqualify business enterprises that hire illegal aliens for large-scale projects from claiming certain tax credits associated with such projects, to provide for related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
Mr. President, the Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffstetler of the 52nd District Chairman. Mr. President, the Senate Committee on Finance offers the following substitute to Senate Bill 465, a bill to be entitled an act to amend Article 2 of Chapter 7 of Title 48 of the Official Code of Georgia annotated relating to imposition, rate, computation, exemptions, and credits relative to income taxes so as to disqualify business enterprises that hire illegal aliens for large-scale projects from claiming certain tax credits associated with such products and for other purposes. Mr. President, that completes the order.
Recognize Senator from 51st. I was in your hometown last night. They like their senator up there. I'm telling you. They like their senator up there.
And they like you, Mr. President. They like you. Senators, my bill is a pretty simple bill, SB 465. We all know how important economic development is in our state. Our Department of Economic Development uses incentives to lure big projects into our state. We have retail projects and wholesale projects, manufacturing projects. So this bill deals with the area where large-scale job creators are recruited into our state. Typically, an applicant that would apply for these tax credits would have to employ at least 1,800 full-time jobs. They would also have to provide health insurance to those employees, and they would have to spend at least $600 million on their investment to create the product and create the jobs for the state before they could qualify for these tax credits. Typically, the tax credit is up to $5,250 per job created, and that would carry forward for 5 years. The only change we made to this bill, actually there were 2 additions in committee. The Finance Committee passed this bill unanimously, but this bill would require that all applicants required to hire legal citizens and legal residents of our state and our country. So this bill just adds that the applicants or the employees must be legally authorized to work here in the United States of America. We also put a 5-year sunset in this bill, and we eliminated the rollover provisions that were already in current law to where the employer could not use the unused portion of the tax credit as a pay forward provision and roll those credits forward. Mr. President, I'm happy to take a couple of questions or I'll yield the well.
Do you have one question, Senator? Recognize Senator from the 30th.
Gentleman yield.
I'll do that for my seatmate.
Is it not true that the city of Villa Rica was the original gold rush in the state of Georgia?
Sir, I think your information may be correct, but the speaker, the senator may know of which he speaks, but not from the perspective of the senator from the 51st. All right, thank you for that good question.
You have no other questions, Senator?
Thank you. Ladies and gentlemen, please vote favorably for Senate Bill 465.
Does any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill vote yea. All opposed, nay. Secretary, unlock the machine. We have the wives of the senator from the 45th, the senator from the 49th, and the senator from the 42nd, all back there in the back. Let's give those ladies a big round of applause while you vote. Why they put up with the men they're married to, I'll never know, but they're good ladies. They're good women. Glad to have you, ladies. On the passage of the bill, the yeas are 49, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 42nd.
Mr. President, I ask unanimous consent that Senate Bill 547 be removed from the table.
Secretary, read the caption.
Senate Bill 547 by Senator Strickland of the 42nd and others, a bill to be entitled an act to amend Code Section 16-6-13 of the Official Code of Georgia annotated relating to penalties for violating Code Section 16-6-9 through 16-6-12 so as to modify the penalties for the offenses of pimping and pandering, to provide that all such offenses shall be punishable as felony offenses, to provide for related matters, to provide for an effective date, and for applicability, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Is there objection? Secretary, finish the caption.
Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland, the 42nd District Chairman. Mr. President, that completes the order.
Recognize the senator from the 42nd. Speak to the bill.
Thank you, Mr. President. Members of the Senate, I bring to you Senate Bill 547. This bill makes the offenses of pimping and pandering go from a high and aggravated misdemeanor to a felony on the first offense. With human trafficking in our state, we've come a long ways, from recognizing the crime itself to giving tools to our Attorney General and prosecutors to take down the industry, to making certain that folks can't turn a blind eye to the industry happening right in front of them and make money off of it, to also standing up and supporting the victims. Today, we go back and focus on the demand itself. Pimping and pandering is directly supporting the criminal enterprise of sex trafficking in our state. This is not a petty, victimless offense, and it's time we start treating it like the crime that it really is. And if I can, Mr. President, I want to stop for a second and recognize some folks in the gallery. Ms. Tricia Boschert, who has a nonprofit, She's My Sister and Freedom and Restoration Network, dedicated to empowering communities to prevent human trafficking, along with students from the Forest School down in Fayetteville. This bill was their idea. They came to me and said, y'all have come so far on human trafficking, but you've left some things out. And this bill was their idea, and today I bring this bill on their behalf to y'all. And I'll be happy to take any questions.
You have no questions, Senator.
I ask for your support of Senate Bill 547.
Does any other senator wish to speak for or against the measure? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 48, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Recognize the senator from the 54th.
Yes, Mr. President, I ask for unanimous consent to remove Senate Bill 556 from the table.
Secretary, read the caption.
Senate Bill 556 by Senators Paynes of the 54th and others, a bill to be entitled an act to amend Code Section 20-2-157 of the Official Code of Georgia annotated relating to uniform reporting system for certain purposes, dual credit courses, and academic eligibility requirements to receive Hope Scholarship, so as to provide for the inclusion of advanced placement and international baccalaureate fine arts courses in the calculation of grade point averages for determining student eligibility for the Hope Scholarships and other scholarships, to provide for applicability, to provide for a definition, to provide for related matters, to provide an effective date, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
Mr. President, the Senate Committee on Higher Education recommends that this bill do pass by substitute. Respectfully submitted, Senator Burns of the 23rd District, Chairman. Mr. President, the Senate Committee on Higher Education offers the following substitute to Senate Bill 556, a bill to be entitled an act to amend Code Section 20-2-157 of the Official Code of Georgia annotated relating to uniform reporting system for certain purposes, dual credit courses, and academic eligibility requirements to receive Hope Scholarship, so as to provide for the inclusion of advanced placement, Cambridge, and international baccalaureate fine arts courses and the calculation of grade point averages for determining student eligibility for the Hope Scholarships and other scholarships and for other purposes. Mr. President, that completes the order.
Recognize the Senator from 54.
Thank you, Mr. President. Friends, this bill is a Department of Education bill brought to me, and it's add to the addition of fine arts courses to Hope Rigor course list. This bill will add advanced placement, international baccalaureate, and upper level Cambridge fine art courses to the Georgia Hope Scholarship Rigor course list in OCGA 20-2-157. Currently, we have English, mathematics, science, social studies, and foreign language. This just adds fine arts to that list so that it'll apply to not only AP and International Baccalaureate, but also to Cambridge Fine Arts. That's all this bill does. Mr. President, if any questions, I'll be glad to answer them. If not, I'll yield the will.
You have no questions, Senator.
I ask for your favorable consent.
Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none, and the previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machine. Did the House ever get back from lunch? Are they taking a little milkshake break this afternoon? Huh? I'm looking at them over there. On the passage of the bill, the yeas are 50 and the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the chairman from Statesboro, Georgia, Senator from the 4th.
Mr. President, I request unanimous consent to raise Senate Bill 515 from the table.
All right. Secretary, read the caption.
Senate Bill 515 by Senators Hickman of the 4th and others, a bill to be entitled an act to amend Part 9 of Article 6 of Chapter 2 of Title 20 of the Official Code of Georgia annotated relating to grants for educational programs under the Quality Basic Education Act so as to revise and streamline provisions relative to the teacher recruitment and retention tax credit program, to provide for definitions, to amend Code Section 48-7-29.23 of the Official Code of Georgia annotated relating to tax credits for teachers in the teacher recruitment and retention program so as to provide for tax credit for amounts, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, finish the caption.
Mr. President, the Senate Committee on Finance recommends that this bill do pass by substitute. Respectfully submitted, Senator Huffstetler of the 52nd District Chairman. Mr. President, the Senate Committee on Finance offers the following substitute to Senate Bill 515, a bill to be entitled an act to amend Part 9 of Article 6 of Chapter 2 of Title 20 of the Official Code of Georgia annotated relating to grants for educational programs under the Quality Basic Education Act so as to increase the maximum number of participating teachers in the Teacher Recruitment and Retention Tax Credit Program from 1,000 to 1,200 each year. Mr. President, that completes the order.
Recognize Senator from the 4th.
Thank you, Mr. Senator. Mr. President, thank you, sir. Again, this is another literacy bill, and this passed out the Finance Committee, which you know is a strong vetting committee, 10-1. Last year, we passed out of this, out of the Senate Resolution 237, where we asked Dr. Jody Barra to look at the Professional Standards Commission to determine why people do not want to be teachers and why people are getting out of education. They did that, and as we've shared with many of y'all, an excellent report on that, and this bill included a recommendation to extend the teacher tax credit along with chronic absenteeism, which we've already passed, along with a big literacy bill and so forth. As we well know, educators are the only workforce whose performance determines the quality and size of all future workforces. And we don't have degreed teachers in the classroom, our students will not be able to read. Georgia cannot deliver on its commitment to schools without a strong, stable educator workforce. This bill actually extends House Bill 32, extends and also modifies House Bill 32, which expires December 31st of this year. Our bill modifies that to a $2,500 tax credit per teacher for 1,200 teachers to a total of $3 million. The couple big things about this bill is this bill only applies to the bottom 25% of the schools in Georgia, but it also specifies specific classes, and those classes are math, special education, career, technical, and agricultural education, or reading, or English, or writing, or English language arts. And the person must also hold a current dyslexia or reading endorsement approved by professional standards. This bill takes effect 1/1/27. It's a 5-year bill. In no event shall the total amount of tax credits earned in this code section exceed $3 million in any fiscal year. Our students will not be able to read if we do not have degreed, qualified teachers in the classroom. Help us fill that gap. Please vote green on this bill. And Mr. President, I yield a well. This is a great bill. Thank you for your support.
Senator's yielded. Does any other senator wish to speak for or against the measure? Hearing none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 49, the nays are 1. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 48th.
Good afternoon, Mr. President. Ask unanimous consent to lift SB 570 from the table.
Secretary, read the caption.
Senate Bill 570 by Senator Steele of the 48th and others, a bill to be entitled an act to amend Article 1 of Chapter 21 of Title 43 of the Official Code of Georgia, annotated, relating to rights, duties, and liabilities of innkeepers so as to provide for a required human trafficking training program for inns and short-term rental properties, to provide for definitions, to provide for training policies and procedures, to provide for the retention of certain records, to provide for limitations, to provide for penalties, to provide an effective date, to provide a short title, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, finish the caption.
Mr. President, the Senate Committee on Public Safety recommends that this bill do pass by committee substitute. Respectfully submitted, Senator Albers of the 56th District, Chairman. Mr. President, the Senate Committee on Public Safety offers the following substitute to Senate Bill 570, a bill to be entitled an act to amend Article 1 of Chapter 21 of Title 43 of the Official Code of Georgia, annotated, relating to rights, duties, and liabilities of innkeepers so as to provide for a required human trafficking program and for other purposes. Mr. President, that completes the order.
Recognize the senator from the 48th.
Thank you, Mr. President. If everyone in this chamber boarded a bus 70 times, that's how many children are trafficked in this state every year. I want that to sink in just for a minute. Senate Bill 570 does not cure that. What it does do is it puts mandatory frontline worker training for hotels, motels, short-term rentals to mandate that the people that work on the front lines, particularly housekeeping, have the proper training from our very own CJCC, or if they work for a national brand that already has their own educational platform on this, within 60 days of hire, they must complete this training to know how to identify and report any sign of human trafficking. This bill has been written in conjunction with all of our friends in the hotel industry, the CJCC, and my only regret is that we can't make the penalties harsher than they are. Those are listed on page 4 of the back of the bill. But it's a good start. It reminds us that our Georgia hotline for domestic minor trafficking is 1-866 end HTGA. That's listed in the bill. We're going to have that posted everywhere to make sure that everybody knows that we're going to do everything we can and that Georgia is serious about our efforts to end human trafficking. Happy to take any questions. Thank you. I yield the well.
Sorry about that, Senator, but you had no questions. Any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor vote yea. All opposed nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 49 and the nays are 0. This bill, having received requisite constitutional majority, is therefore passed by substitute. Senator from 33rd, for what purpose do you rise?
I ask for unanimous consent to excuse the senator from the 22nd for business inside the Capitol.
Without objection, the senator from the 22nd is excused. Recognize the senator from the 42nd. You got a busy day today, Senator.
Hopefully the last one, Mr. President. I ask unanimous consent that Senate Bill 569 be removed from the table.
Secretary, read the caption.
Senate Bill 569 by Senator Strickland of the 42nd and others, a bill to be entitled an act to amend Title 40 of the Official Code of Georgia annotated relating to motor vehicles and traffic so as to provide for the issuance of emergency vehicle-like permits for towing services companies in certain instances, to revise a definition, to provide related matters, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
Mr. President, the Senate Committee on Public Safety recommends that this bill do pass. Respectfully submitted, Senator Albers of the 56th District, Chairman. Mr. President, that completes the order.
Recognize the chairman, the old country lawyer from McDonough, Georgia.
Mr. President, I wore my boots for you today. You haven't complimented them yet. I wore them just for you. Thought you might recognize them.
Those are some of the ugliest boots I've ever seen.
Just some country lawyer boots, Mr. President. Members of the Senate, I bring to you Senate Bill 569. This bill simply fills a hole in the law that we have where record trucks are not able to get around traffic to get to accident scenes to clean up wrecks. And the bill allows for record trucks that are part of the federal TRIP program. And this is a program where trucks are incentivized to clean up certain hot spots in our state, such as where I'm from in Henry County, the interstate, and as fast as they possibly can, and also records that are under contracts with local governments. These are all law enforcement initiated tows. Law enforcement calls records out to clean up the interstate. This simply allows the colonel of state patrol, if the record service completes the training that he or she implements, to get red light permits for their vehicles. And we all get very annoyed when we get stuck in traffic, and that's obviously a big issue. But bigger than that, a lot of the folks who die on our roads die in secondary accidents, and this bill will help make sure we clean up our wrecks faster. Happy to answer any questions.
You have no questions, Senator.
I ask for your support. Thank you.
And that was such a mean comment I made. You have very nice looking boots right there. Yeah, they're pretty nice. I couldn't pull them off. You can pull them off. Yeah. And you know, your dad is the countryman in the family. You know that, don't you? He's real countryman. He's a good man too. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill. All those in favor of the bill vote yea. Opposed, nay. Secretary, unlock the machine. Recognize the senator from the 14th. For what purpose do you rise?
Parliamentary inquiry, Mr. President.
State your inquiry.
Mr. President, this bill is about towing. I'm trying to think of any other policy issues this might have been a good vehicle for. I don't know. Can you think of any, Mr. President?
You know, Senator, it could have been a good thing for a lot of things, I guess. Senator from 42nd, for what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that the senator from the 14th had brought an amendment? He could have put red lights on that and had it go to the floor very quickly with this bill.
All right. They got an inside thing going there. Recognize senator from the 20th. For what purpose do you rise?
Mr. President, parliamentary inquiry.
State your inquiry.
So this is a towing bill, is that correct?
That's what it feels like.
But the author of the bill was wearing boots, so I just don't know if it was towing or booting or what we're talking about.
Oh, wow. Day's getting long. Day's getting long. How many folks in this room are running statewide now? Can I get a show of hands? Let me get a show of hands. How many folks in this room are running statewide? Rise, stand, and be counted. How many statewide folks we got? Rise, stand, and be counted. Here we go. You're running statewide. You're running statewide. Man. All right. All right. On the passage of the bill, the yeas are 45, the nays are 5. This bill, having received the requisite constitutional majority, is therefore passed. All right. Recognize the senator from the 46.
Thank you, Mr. President. I move that Senate Bill 604 be removed from the table.
Secretary, read the caption.
Senate Bill 604 by Senator Cowsert of the 46 and others, a bill to be entitled an act to amend Title 16 of the Official Code of Georgia annotated relating to crimes and offenses so as to provide the Attorney General concurrent jurisdiction with district attorneys to conduct criminal prosecutions of violent crimes, illegal immigration offenses, and fentanyl offenses, to provide for related matters, to provide for an effective date and applicability, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Any objection? Without objections, Secretary, finish the caption.
Mr. President, the Special Senate Committee on Investigations recommends that this bill do pass by substitute. Respectfully submitted, Senator Cowsert of the 46th District Chairman. Mr. President, the Special Committee on Investigations offers the following substitute to Senate Bill 604, a bill to be entitled an act to amend Article 1 of Chapter 18, Title 15 of the Official Code of Georgia annotated relating to general provisions regarding prosecuting attorneys so as to give the Attorney General in certain circumstances the option of being appointed in the place of a disqualified district attorney and for other purposes. Mr. President, Senator Jackson of the 41st offers the following amendment. Amendment 1, amend the substitute to Senate Bill 604 by inserting after that on line 23 the following, except in the event of the voluntary recusal of a district attorney. Mr. President, that completes the order.
Recognize a senator from the classic city, beautiful Athens, Georgia.
Thank you, Mr. President. Senators, this is another bill that we came up with the Special Investigative Committee. Our investigation showed that a number of the district attorneys feel like they have inadequate staff and resources to prosecute all the crime in their circuits. Many of them basically were crying out for help or assistance, additional funding so they could hire more prosecutors to try to reduce their backload. In fact, the district attorney in Fulton County said they got about 2,000 cases that are backed up they're trying to work their way through. This is an attempt to give them a resource to do that. It allows a district attorney to request the assistance of the Attorney General's office to prosecute certain types of crimes. The first are violent felonies that are listed as the 7 deadly sins. Those begin at line 40 and go through line 48. The next is drug trafficking type offenses, and then prosecutions of illegal aliens, and finally, prosecutions under the Racketeering, Influence, and Corrupt Organizations Law, the RICO law. As we've learned, those type of prosecutions are very complicated, very time-consuming, and they take a long time to try. So we wanted to give the different district attorneys around the state the option of asking for assistance from the Department of Law, which has about 150 attorneys on staff and might be able to help reduce this backlog on those serious crimes. Finally, we noticed a problem that came up really also sprung out of the Fonnie Willis disqualification. Current procedures are if a DA recuses themselves or get removed from a case, it goes to the Prosecuting Attorney's Council to go try to find another DA somewhere around the state that will assume the prosecution, and if not, the executive director of PAC can take over a prosecution. And you noticed on 2 different cases in really the last year, they shopped all over the state, could not find another district attorney either willing or had the resources to step up and prosecute a case. So this gives the district attorney the sort of right of first refusal in a recusal or disqualification case to step up if they have the resources and take over that prosecution. And if not, it goes back to the existing process. Very simple, a way to try to streamline processes and to give extra manpower and assistance to District Attorney's Office when they're prosecuting serious crimes. Glad to take any questions, or of course I'll yield the well. I do anticipate the amendment is to effectively gut that second portion that allows the Attorney General to have an opportunity to step in on recusals or disqualifications. I would not agree to that. I think this addresses a problem, and if you go with that amendment, you leave the same problem there.
You have no questions, Senator.
Thank you. I yield the well.
Senator from the 41st, if you'd like to speak to your amendment.
Thank you, Mr. President. I rise and request your support of this amendment that I have for SB 604. So what it does is it's very simple. I acknowledge that the Attorney General's office can be very helpful to our DA's offices across the state when they are not able to take on a case. However, when a DA recuses themselves, not due to some type of misconduct, but because of conflict or for some other reason, when they self-recuse, I do not believe that the AG's office needs to get the first bite of the apple. We have PAC. We spend state dollars for the Prosecuting Attorney's Council to do this very thing, to help find and to do the work of finding someone who can step in the event that a DA cannot take a case. So what this amendment does, it's very simple. It says, listen, if a DA recuses themselves, then PAC will continue to function as it does today. PAC will be the one who helps try to find someone. And it preserves the author's original language because it still allows a pathway. If PAC doesn't find someone, the AG's office will still have an opportunity to take over, which right now doesn't exist. So I want to be clear, I support so much of this underlying bill. And I am grateful to the senator from the 46 for wanting to bring more resources to counties like mine. I'm grateful for that. However, I'm very clear that if someone simply recuses themselves, there's been no misconduct, we do not need to send that straight to the AG's office. I believe that that actually would slow down and delay justice if they have to go to the AG's office for the first bite of the apple, as opposed to using the PAC instead of using PAC. PAC is very skilled. That's one of the things we pay PAC to do, is to find an aid of the DA to step in the event of a recusal. So I'm making a very precise cut in this bill. If a DA is disqualified for misconduct, the AG gets the first bite of the apple. But if it is simply a recusal, then we continue to function as we have, with PAC being the group that facilitates the change. I'll yield for questions.
You do have a couple questions, Senator. Recognize the senator from the 19th.
Thank you, Mr. President. Senator Yield?
Yes, I will for the Appropriations Chairman.
Thank you. I am sensitive to what you're saying. I'm concerned about something else. I wonder if you've thought about this. In situations where a district attorney may feel like they need to recuse themselves, do you think that this might cause some type of forum shopping where they would wait till the end, to see if they're going to be disqualified by the court, who then say, hey, wait, I don't want the court to decide. I'm going to go ahead and recuse myself voluntarily so PAC can decide who my successor is instead of the Attorney General?
No, I'm not concerned about that at all. DAs have been very clear that it's not uncommon for them to just need to do a swap, right? Clayton County needs someone and DeKalb County needs someone, so they simply swap cases. We don't need the AG's office involved in that. I'm not concerned about shopping around. And let's also be clear, PAC is a state agency. So if PAC is somehow in cahoots with these DAs to shop around for the proper forum, then we've got a bigger problem. So no, I am not concerned about that.
Recognize the senator from 46.
Senator Yield?
I will, yes, sir.
So in the Ahmaud Arbery case down in Brunswick, That's what the senator from 19th is talking about kind of happened there. The original prosecutor that had refused to prosecute recused themselves. Then it goes to another prosecutor that was found to have a conflict, and then it went to another one who happened to have gone to college with me, Tom Durden, whose office didn't have the resources. And that thing got delayed for 6 to 12 months, and it ultimately ended up with the AG's office making the appointment. I don't want to inadvertently delay prosecutions. I'm inclined to go along with your amendment if it could have unanimous support here so we could address the problem. But I think is there a way to tweak this to make certain that it doesn't involve forum shopping or delays in prosecution?
Yeah, so thank you for that question. I think the example that you've given is actually, I think it speaks to a different issue in that you had people who are very closely knit who are all attached to one another, but I think ultimately the example that you give, it shows that the process does work. It took a couple of times to get to the right place, but I don't believe that anyone was intentionally trying to find a DA who would be in cahoots or who would need to conflict out, right? So it took a couple of bites of the apple to get to the right place, and that ultimately was the AG's office. But it's a process that works most of the time to just have PAC make this happen quickly, to not delay justice. The example that you've given is very unique, very specific, and very rare. What happens much more frequently are these kind of quick recusals of people just needing to step out of a case. And so I don't want to delay things by clogging up the AG's office with every single recusal, when really I believe, sir, that the heart of this you're trying to get at is when a DA has misconduct and is disqualified, you want someone to step in from the AG's office. That makes sense. I support that. So that's what I'm trying to get at, is trying to make sure we keep this as tight as possible. I believe that the current system that we have works and that it works well. And every once in a while it will break down, but at the end of the day, it still worked.
Okay. Well, will you agree to continue to work with me through the process if we can refine that language to avoid those type of problems that the senator from the 19th and I have observed as we go through the legislative process?
Absolutely. Thank you, Mr. Chairman. I am deeply committed to helping make this work. I want more resources available to our DAs across the state, and I think that is what your bill is trying to get to. I just don't want to kink up the work, so I'm happy to work with you on this.
Well, with that assurance, then I will not object to your amendment.
Thank you. I appreciate that. I will yield the well.
Wow. Man, who says there's not bipartisan work? He goes on, yeah, oh, wow. I mean, that was just, Senator from the 14th, I mean, that just felt really genuine, didn't it? I mean, that was like a nice moment. I mean, it's like a Hallmark moment right there, so it's really nice. All right, so let's take up amendment number 1. And obviously, as you all heard, there shouldn't be any objection on amendment 1. Amendment 1 has been adopted. The question is on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor of the bill vote yea. Opposed, nay. Secretary will unlock the machine. Senator from the 2nd, for what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
Mr. President, is it not true by the amazing hospitality of the senator from the 46th and my colleague at the well? I'm convinced that the well does work, and I'm voting yes on this legislation because of that.
I know. I think it moved us all, Senator. I think it moved us all. Recognize Senator from the 43rd.
Parliamentary inquiry, Mr. President.
For what purpose do you rise?
I rise to acknowledge that the chairman, or senator from the 46th, it took courage to execute justice. Thank you, Mr. Chairman.
The senator from the 46 is a good man. He's a good man. On the passage of the bill, the yeas are 47, the nays are 2. Wow, these two right here. Right here. Y'all, the dinner's coming up. Y'all can prevent them from having any if you want some, but on the passage of the bill, the yeas are 47, the nays are 2. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 51st.
Thank you, Mr. President. I ask for unanimous consent to remove Senate Bill 591 from the table.
Secretary, read the caption.
Senate Bill 591 by Senator Gooch of the 51st and others, a bill to be entitled an act to amend Article 2 of Chapter 11 of Title 16 of the Official Code of Georgia annotated relating to offenses against public order so as to prohibit the disruption of a religious service, to provide for enhanced penalties, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none. Secretary, finish the caption.
Mr. President, the Senate Committee on Judiciary recommends that this bill do pass. Respectfully submitted, Senator Strickland of the 42nd District Chairman. Mr. President, that completes the order.
Recognize the senator from the 51st. Speak to the bill.
Thank you, Mr. President. Senators, Senate Bill 591 is a pretty straightforward, simple bill. Today in Georgia law, it is forbidden, in fact, it's a misdemeanor, if you interrupt a memorial service or a funeral. This bill simply adds religious services to that same code section. It will remain to be a misdemeanor, punishable for up to 12 months in jail and $1,000. We also added on the last line of the bill, if you interrupt or disrupt, interfere with a memorial service for a military service, it would be an aggravated misdemeanor, which would be up to 12 months in jail and up to $5,000 fine. Mr. President, I'm happy to take questions, or I'll yield the well.
You do have a couple questions, Senator. Recognize the senator from the 2nd.
Senator, do you yield?
I sure will, for the man from Savannah.
Now, Senator, I happen to be a Baptist preacher, ordained and licensed in the Baptist church, and I have been to many meetings where the preacher has been put out of a Baptist church, but I've also been at meetings where those who did not sustain the votes have shown up to voice their opposition to the preacher, pastor at that particular church. Senator, would this now criminalize those people that exercise that discourse and worship services when church business may come back and show back up into the worship service?
We don't think this has anything to do with the First Amendment rights, and I don't believe that you will be criminalized unless you're found to be guilty by court. So you would have the right to defend a charge if there were one to be brought forward, just like you would on the current law today. And we haven't seen that to be a real issue here in Georgia, but there's been other situations around the country where it's becoming a problem. So it doesn't discriminate on any type of religion. It would be any religious services whatsoever.
And likewise, Senator, do you further yield?
I sure will.
Senator, I've also served in the funeral service for many families, and those may involve families where we may do a service for an individual who is a member of the military, and there may be a disagreement from family members, and that disagreement may show up at the cemetery, usually where those services occur, especially when folks travel from Savannah, for example, to Beaufort National Cemetery or other cemeteries in the state of Georgia. So now, Senator, if a family member were to show up and disrupt that service, would they now also face criminal penalty while experiencing grief?
That would too also be left up to the jurisdiction in that community, and it would be left up to the court system to determine whether that was a disrupted service or not. And I believe all military funerals should be held of utmost respect, and the dead should be put to bed and buried and not be disrupted by either family members or anyone from the outside as well.
And Senators, my final question, if you yield.
Yes, sir, I will.
And so should a district attorney in a particular judicial circuit not choose to move forward with charges, would it be your presumption or your understanding that that district attorney would be derelict of their duties if they chose not to foresee those charges and chose to just unilaterally dismiss them?
I believe there's procedures in place in Georgia law that would address that. If a DA is not doing his or her job, then the PAC would be able to take action on that district attorney.
Recognize Senator from the 14th.
Does the senator yield for a series of questions?
I will yield for a couple.
Okay.
Yes, sir.
Senator, did Don Lemon text you to tell you he was going to disrupt a church service in the state of Georgia?
I'm not sure what you just said.
Did Don Lemon send you a text message telling you he was planning to come to Georgia to disrupt a church service?
I've never met the man before, and I've never heard from him.
So is the senator aware of any imminent harm or risk in the state of Georgia that would require this legislation?
It could happen any day, Senator, and we would want to protect our religious freedoms in this state, and we would want to protect everyone who wants to worship their Lord and Savior.
Senator, further yield?
Yes, sir.
Senator, is it true that yesterday you or your campaign team generated an AI photo of me carrying a box of cereal? Is that true?
That is correct.
Okay.
You look good in that photo.
Second question. Are you aware that one of your colleagues introduced legislation this session that in its original form would have made it a felony to do what you did with that AI image?
I'm not a lawyer, so I'm not sure if I was on that committee when that bill came through or not. But
final question, Senator.
Go ahead, let's hear it.
Do you believe in the consistency in the application of criminal law, or are you using criminal law bills to do political messaging?
Sir, I'm trying to protect people's right to worship their religion, and also to protect people who are dead and are being buried and having a memorial service. And I'm also trying to give dignity to those who have died, who have defended our freedoms in our country.
I'll congratulate the senator for staying on message.
Yes, sir. Thank you for those good questions.
All right,
Mr.
Senator.
President, I'm happy to yield the well at this time.
All right, Senator is yielded. Does any other senator wish to speak for or against the measure? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill. All those in favor will vote yea. All opposed, nay. Secretary, unlock the machine. On the passage of the bill, the yeas are 39 and the nays are 13. This bill, having received requisite constitutional majority, is therefore passed. Well, if I could have everybody's attention real quick, we have a very, very special guest with us today. A man who started his career right here in this body, the youngest senator elected to this esteemed body at the ripe old age of 25. About 14 years ago now, I believe. And he now serves as our agricultural commissioner. And I like to think of him, well, number one, he's my friend, and he's been my friend for a long time. But number two, I think he's the best ag commissioner in the country, of this great country here. So y'all give a warm welcome to Commissioner Tyler Harper.
Well, good afternoon to my good friends. It is always good to be back in the State Senate, the upper chamber of the General Assembly. But it's always good to be back, Mr. President. Lieutenant Governor, thank you for your friendship and your esteemed service. And definitely know that we're going to look forward to working with you moving forward. Yes, sir, definitely. But we're going to miss a lot of folks. The senator from the 15th, senator from the 42nd. I know there's some others in here that are moving on and looking for higher office, but Dean, thank you for your service. I appreciate your friendship. Yep. Yes, sir. I owe you a ride. I do. I remember when I first come to this august body and I stood in that well on a stool. Dean, you let me know right quick like that stool, this stool right here. That's right. You let me know right quick like that I didn't need that stool, and I appreciate you. I appreciate your friendship, and you're going to be missed. But I appreciate what all of y'all are doing. Thank you for the work that we do together in serving our state, especially our state's #1 industry, agriculture. Our work together, helping our farmers, our farm families, and consumers across this state is important. And I appreciate the work that y'all do every single day to help us do just that. I know y'all got a lot of work to do, so I'm not going to be very long. I'm going to be very brief and get out of your way and let y'all go back to work. But thank you for what you're doing for our great state. I look forward to our continued work together to ensure this state continues to be the best place to live, work, worship, and raise a family. And our #1 industry and our farm families can continue to be successful in doing that every single day as well. So thank y'all. God bless you. And as always, y'all keep plowing, and I'm going to keep plowing with you. Good to be with y'all. Thank y'all very much. Have a great day.
Recognize Senator from the 16th.
Mr. President, I move that SB 324 be removed.
Secretary, read the caption.
Senate Bill 324 by Senator Harbin of the 16th and others, a bill to be entitled an act to amend Chapter 25 of Title 33 of the OCGA relating to life insurance so as to provide for certain protections for life insurance policyholders and beneficiaries, to provide for an owner of a life insurance policy or annuity to be represented by a local agent when such policy or annuity is sold, to provide for such owner to be represented by a local agent when such agent does not have a contract with such insurer, to provide such owner with an annual notice report on such police or annuity, to require an insurer to conduct a quarterly search of the National Association of Insurance Commissioners policy locator, to provide for annual reporting, to provide for rules and regulations, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none. Finish caption.
Mr. President, the Senate Committee on Insurance and Labor recommends that this bill do pass by substitute. Respectfully submitted, Senator Harbin of the 16th District Chairman. Mr. President, the Senate Committee on Insurance and Labor offers the following substitute to Senate Bill 324, a bill to be entitled an act to amend Chapter 25 of Title 33 of the Official Code of Georgia annotated relating to life insurance so as to provide for certain protections for life insurance policyholders, to provide for a short title, to provide definitions, to provide for insurers to conduct policy locator searches, and for other purposes. Mr. President, that completes the order.
Recognize Senator from the 16th.
Thank you, Mr. President. I appreciate that. This is SB 324 is a policyholder bill of rights. We don't think about life insurance is that life is long. People buy life insurance and they may not die for 20 or 30 years. And what this bill does is give some rights to a policyholder that really needs to be done. For first, let's talk about unclaimed property. We currently have $3 billion in our unclaimed property fund, and right now, under the current law, it says that a life insurance company will check the Social Security death benefit list to see if somebody is dead. If they cannot find the beneficiary, the money goes to unclaimed property. Now, what this bill does in the first part, in the unclaimed property section, is it requires not only to check the Social Security death benefit list, but it also requires the checking of the National Association of Insurance Commissioners policy locator. That is a national. What this bill is requiring Georgia companies to do is to check the National Register. That website that was created by the National Association has collected over $13 billion in policies that people couldn't find. And so that we've included, that's part of the process, that when somebody dies, not only do you check the Social Security death benefit, you know they're dead, but also you make an attempt to look at the policy locator that the National Association has put in place. The second part of this Bill of Rights is this: if your company is sold to another company, that your agent continues to get the reports on it so that you bought it from him, he knows the policy. Currently, what happens is when a company sells to another company, they have no obligation to send you the report or your agent the report, and that's who you bought it from. And so this would require that to continue. We also have asked in this bill that a form be created by the insurance department that when you need to know something, you can have it signed by your attorney, CPA, or a life insurance agent, and he can send that into a company, and the company has to honor that form created by the Department of Insurance. If we don't do it that way, then every company will want their own form. This takes one form from the Department of Insurance and makes it uniform so that that handles that way. And then the other part is that many policies are paid up. You find a lot of policies paid up, 20-year pay, whatever. Well, they quit sending an annual statement. This requires an annual statement to be sent on a policy that's active so that the policyholder knows what's going on, and they don't have to do it under current law. We fixed that portion. And then the policy locator is the biggest thing I see here, is that people are unaware that there are policies. I talk to clients all the time that do not have any idea of their mother or father if they have any life insurance in place. And older policies do not have the identification. Older policies do not have Social Security numbers, do not have dates of birth or addresses of the beneficiaries. And that money, if they can't find the beneficiary, goes into unclaimed property. So I believe this is a good thing for the citizens of Georgia, a good thing for people who have life insurance, that their beneficiaries get paid. And that's what this is all about. Mr. President, yes, sir. Any questions?
No questions, Senator.
No questions.
Senator, this is about the 5th or 6th time this thing's been brought to the floor, isn't it? Through the years? Okay. We were talking back here. You might be going on 8 or 9 years with this one here. So, okay. All right. We're going to have to hammer down on the House on this one, I think. So, any other senator wish to speak for or against the measure? Hearing none. Questions on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Question is on the passage of the bill by substitute. All those in favor of the bill will vote yea. Opposed, nay. Secretary, unlock the machine. Hey, it's still undefeated. All the passages of the bill, the yeas are 50, nays are 0. This bill, having received the requisite constitutional majority, is therefore passed by substitute. Recognize the senator from the 23rd.
Thank you, Mr. President. I request that Senate Bill 418 be lifted from the table.
Secretary, read the caption.
Senate Bill 418 by Senator Burns of the 23rd and others, a bill to be entitled an act to amend Chapter 1 of Title 51 of the Official Code of Georgia annotated relating to general provisions regarding torts so as to provide a cause of action against the knowing and unauthorized use of an individual's photograph or image together with representations of nudity or sexually explicit conduct, to provide for states of such cause of action, to provide for definitions, to provide for related matters, to repeal conflicting laws and for other purposes. Mr. President.
Is there objection? Hearing none, finish the caption.
Mr. President, the Senate Committee on Judiciary recommends that this bill do pass by substitute. Respectfully submitted, Senator Strickland of the 42nd District, Chairman. Mr. President, the Senate Committee on Judiciary offers the following substitute to Senate Bill 418, a bill to be entitled an act to amend Chapter 1 of Title 51 of the Official Code of Georgia annotated relating to general provisions regarding torts so as to authorize the Attorney General or an appropriate prosecuting attorney to bring civil enforcement actions against the knowing and unauthorized use of an individual's photograph or image together with representations of nudity or sexually explicit conduct, to provide for stays of such causes of action, to provide for a limitation of liability, to provide for definitions, to provide for a related matter, to repeal conflicting laws, and for other purposes. Mr. President, Senator Burns of the 23rd and others offers the following amendment. Amendment 1, amend the Senate Committee on Judiciary substitute Senate Bill 418 by replacing causes of action with civil enforcement actions on line 5 by replacing cause of action with civil enforcement action on line 42. Mr. President, Senator Burns of the 23rd and others offer the following amendment. Amendment number 2 to Senate Bill 418 by replacing $1,000 with $10,000 on line 36. Mr. President, that completes the order.
Recognize the senator from the 23rd.
Thank you, Mr. President. Colleagues, this is an image protection bill. It protects Georgians, especially minors, from abuse of unauthorized exploitation of their image. It protects them from ridicule or shame, embarrassment, bullying, blackmail, or any other types of exploitation because that individual's image has been used in an unauthorized manner to represent either nude or sexually explicit conduct. It authorizes the Attorney General or appropriate prosecuting authority to pursue a civil course of action, a civil action against an abuser, and it would ensure that our children are protected even to the point of 10 years after they reach their 18th birthday, and in reality, even someone who is deceased whose image may be violated. So, there are 2 amendments to this. They simply ensure that the language is consistent so that the language shall read civil engagement action on lines 5 and lines 42, I believe. And then it changes. The second amendment is a friendly amendment patterned after the Senate Bill 540. We've increased the penalty from $1,000 to $10,000, up to $10,000. With that, Mr. President, I yield for questions, or I yield the well.
Yeah, one question.
One question.
Recognize the senator from the 41st.
Thank you, Mr. President. Does the senator yield?
Absolutely.
Senator, can you tell me, or can you define what use is, and does it include personal use, or is this only illegal if you distribute?
No, this is personal use or any form of use, either personal or commercial.
Do you further yield?
Yes, certainly.
So if a person has an image of someone who is nude and has that just in their on their person, they could be liable for up to $10,000?
If they do it knowingly without that individual's knowledge or consent, they would be held responsible.
Does the senator further yield?
Well, one more question.
Yes, and I'm looking at line 17 where it defines image.
Yes.
And it says that it's readily identifiable depiction of an individual, including but not limited to a photograph. So if a person were to draw a subject in the nude, would this be a violation of this code section?
The image would have to be recognizable And again, without that individual's consent, knowledge and consent, we're protecting the image and the rights of the individual, whether it be a child, a minor, or an adult. And as I pointed out, even beyond that, if they were to be abused after their death.
Thank you.
Thank you, Mr. President. I yield the well.
Senator is yielded. Does any other senator wish to speak for or against the measure? Senator from 26, would you like to speak? Would you like to speak to this? Chair hears none. Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. The question is on the adoption of Amendment 1. Adoption of Amendment 1 authored by the senator from the 23rd. Is there objection? Hearing none, Amendment 1 is added. Question is on Amendment number 2, authored by the senator from the 23rd. Is there objection to Amendment number 2? Hearing none, Amendment number 2 is adopted. Questions on the adoption of the committee substitute as amended. Is there objection to the adoption of the committee substitute as amended? Hearing none, the committee substitute as amended is adopted. Is there objection to agreeing to the report of the committee which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. Questions on the passage of the bill by substitute. All those in favor of the bill vote yea. All opposed nay. Secretary will unlock the machine. On the passage of the bill, the yeas are 40 and the nays are 8. This bill, having received the requisite constitutional majority, is therefore passed by substitute. We have a special announcement from the President Pro Tem here, the man from Perry.
Ladies and gentlemen, we have worked awfully hard today since 9 a.m. this morning, meetings probably prior to 9 a.m., and I know you've developed quite an appetite. So we have Maggiano's in the anteroom for the senators, and I would ask that the senators be allowed to go first whenever the president breaks us, gives us a break. And but we do have dinner for you. Be sure and look at the sponsor board and thank the sponsors.
He's saying we got 10 minutes.
All right, thank you.
Did the House ever get back from their lunch break? Huh? They're working? I figure they need a midday snack now, right? Senator from 37th, could you come up here real quick? We're going to take it one more bill so they can get everything set up in there. Recognize the senator from 37th.
Mr. President, I'd like to ask unanimous consent to remove Senate Bill 593 from the table so we can act on it as a body.
Secretary, read the caption.
Senate Bill 593 by Senator Hatchett of the 50th and others, a bill to be entitled an act to amend Chapter 71 of Title 36 of the Official Code of Georgia annotated relating to development impact fees so as to provide for disclosure of impact fees upon transfer of ownership, to provide for related matters, to provide for an effective date, to repeal conflicting laws for other purposes. Mr. President, that completes the order.
Is there objection? Hearing none, Secretary, finish the caption.
Mr. President, the Senate Committee on State and Local Government Operations General recommends that this bill do pass by substitute. Respectfully submitted, Senator Dixon of the 45th District Chairman. Mr. President, the Senate Committee on State and Local Government Operations General offers the following substitute to Senate Bill 593, a bill to be entitled an act to amend Chapter 71 of Title 36 of the Official Code of Georgia annotated relating to development impact fees so as to provide for disclosure of impact fees upon transfer of ownership, to provide for related matters, to provide for an effective date, to repeal conflicting laws, and for other purposes. Mr. President, that completes the order.
Recognize the senator from 37th.
Mr. President, ladies and gentlemen, the Senate, Senate Bill 593 came from the State and Local Government Operations Committee. It's a procedural bill, but it's an important one. What it does is it allows folks who are considering the purchase of land for development to make a written application to the local governments to figure out what the impact fees would be. Currently, there's no provision that unless you own the property to understand what all the potential impact fees can be. And as we know, impact fees are a development tool that a lot of governments use to sort of forward load infrastructure costs to make sure infrastructure costs aren't just paid by existing residents. So what this allows, again, Mr. President, allows, if a specific request is made by a potential purchaser, to have the local governments lay out in detail the specific impact fees if they provide a specific project scope. Glad to take questions.
You have no questions, Senator.
Thank you, Mr. President.
Is there any other senator wish to speak for or against the measure? Is there objection to the previous question being ordered? Chair hears none. Previous question is ordered. Question is on the adoption of the committee substitute. Is there objection to the adoption of the committee substitute? Hearing none, the committee substitute is adopted. Is there objection to agreeing to the report of the committee, which is favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Is there objection to the main question being ordered? Chair hears none. The main question is ordered. The question is on the passage of the bill by substitute. All those in favor vote yea. All opposed nay. Secretary, unlock the machine.